Okay, good morning everybody, and welcome to the November 17th Board of Adjustments and Appeals. My name is Larry Otterback. It's a little bit after 9 o'clock, and we are now in session. Please take this time to make sure your phone is silenced. If you need to take a call, please excuse yourself from the courtroom. Just make sure it's off when you come back in. Board members, please make sure your mics are on, phones are off. And with that, I'm going to go ahead and swear staff in.
Solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Okay, so for the first case, what we're going to do is Gretchen is going to give us an intro of the administrative review. Ryan's going to come forward and give us a staff report. And then we're going to hear from code enforcement, and I will ask Ryan if there's anybody that he wishes to call in support of the review. When we're done with that, there may be a round of questioning by board members to Ryan. When we're done, I'm going to call Mr. Grant forward. You'll come forward, raise your right hand, be sworn in, state your name and address, and then you can tell us your defense against the administrative review. I'll ask you also if you have anybody that is here that you wish to call forward to speak in support of the defense. And when we're done with that, there might be a round of questioning by board members to you. When we're done, I'll close the floor and open it up for general discussion among board members, and then we'll make a final decision at that point. With that, Gretchen, can I get you to read the first case, please?
Docket 3200, an administrative review of a previously issued conditional use permit at 1515 Riverside Drive, Prospect.
Hey, Ryan.
Thank you. Ryan Fisher, Senior Planner, Oldham County Planning and Development. There is actually no staff report for this. To my knowledge, there is nobody that is here to speak for or against this other than our planning and zoning staff, Jim Urban and Adam Baer, the code enforcement officer. There is somebody back there. For or against? Okay. So one against. Okay. That's all I have.
And board members, Jim Urban, I'm the Director of Planning and Development Services for the county, and this is an administrative review of an old case, docket number 3200. You received a package from me in the state statute KRS 100 in review of conditional use permits. Anytime there appears to be a violation of the conditions or the case, I'm required to produce a report, which I did, and I sent out on it's dated October 12th. So we gave actually plenty of time for the defendant to consider what we're saying in it. I was also required to send a copy of that report to the chairman of the Board of Adjustments. He did receive it. You've all received it in the meantime as a part of the packet. The reason we're here today is because during the original case, which was docket number 3200, Mr. Grant testified that neither floor of this accessory building would be used for residences. The case was that Mr. Grant had lived across the street. This was a separate lot on the opposite side of the street what he owned. He wanted to put a garage on the property, which made a lot of sense. There wasn't a primary building. His primary building was across the street. So it was a conditional use for an accessory building without a primary building on the property, so it was granted. Over the years, there has been many times we've talked about whether or not a person or people are living in this garage. Mr. Grant has been quite cooperative with us and at least talking to us, and at one point years ago we went inside the building, but in recent history, Adam and Baer, who's our code enforcement officer, we had put out cameras. And Adam is going to testify in a minute that his observation from the pictures are that there is somebody staying in the property. We believe that's in direct conflict with the statement that Mr. Grant said that nobody would be using the property for resident. You have, again, as part of your report, the original minutes from the conditional use application. You also have a copy of KRS 100-237 that talks about conditional use permits, and specifically item number 2 and number 4 underneath 100-237 states that granting the conditional use permit does not exempt the applicant from complying with all of the requirements of building, housing, and other regulations. And there was never a building permit for a residence on this property. And then item number 4, this is really where we are today. The administrative officials shall review all conditional use permits and just to make sure that they're in compliance. I won't read the whole thing. You also have a recent case history since March of 2022. This has been going on for some while, but we're going to focus on just what we know since March and why we're here this morning. So I'm going to ask Adam to come up and present his evidence regarding his beliefs.
Madam Mayor, Oldham County Code Enforcement. I started receiving complaints on this property back in March while I was doing other studies, other cases in the area on Riverside Drive. With the complaints that I received from owners in the area that someone was living at 1515 Riverside Drive, they told me that there was old case files and that I should speak to Jim Urban about it. So that's when I went to Jim to try to discuss what was going on, and he told me there were old cases involved and that I should look back into it. So that's kind of where it starts, and you've got the timeline of Riverside Drive. I don't know if you want me to go through it or not. You can kind of read through it. But from talking to Jim, we decided to go ahead and, with all the complaints that we were receiving, to go ahead and install some cameras on the property that is now owned by the county across the street from 1515 Riverside Drive, and take some photographs of the property to see if someone was living at the property or not. I installed the cameras on July the 20th and began going down there periodically every few days to take the video cards out, bring them back to my office, and review the videos. And that's when, after several weeks of looking at different pictures, it's my belief, based off of the evidence that I've seen, that someone is residing at 1515 Riverside Drive. Somebody's staying the night there. I've got some photos. You all have got them in your packet. You can kind of see it a little clearer. I'm going to pull them up right here. This is just one typical day that I observed in the photos. I'm going to pull it up here, and if you have any questions, please ask. So this is July the 31st at 6:54 in the morning. Sitting close to the road on Riverside Drive, looking across the street to 1515. As you can see, there's a truck. This is a black truck right here. And then there's a red truck on the property right here. Both of these trucks are there daily on a regular basis. And how do I go to the next picture? Okay. So this picture was taken at 7:01. As you can see, the black truck is now leaving the property. At 7:37, you see a gentleman outside of the property walking a dog. The red truck is still there. At approximately 8:30, at 8:33, the red truck is leaving the driveway. So at 6:10, the black truck returns. 6:10 p.m., the black truck returns to the property. At 6:42, the red truck returns to the property. There's two people at the property currently. This is at 8:15. The black truck is gone. It's actually, from the photos that I've viewed daily, the black truck is in the garage right now. The camera that I have only takes still photos. when it's motion activated. And I have several photos from different days showing that the garage door opening and the black truck being put in the garage. And that's how I can conclude that the black truck currently is in the garage. This is the gentleman that drives the black truck on a regular basis. At 8:24, you see the red truck backing out, and he's not really leaving the property. He's actually backing it into along the trees in the front of the property. If I can go back, I'll show you kind of where he parks at. He parks in this general area right here with the red truck. So he'll back it out and then kind of back it into this area. So the red truck's actually right there at 10:41. At 6:43 the next morning, the black truck has been pulled out of the garage, and then we pretty much start a typical day over again. And this is the typical day. The timeline is pretty consistent, and this is several weeks of me watching this, that it's consistent every day of this is what's going on. Do you have any questions over the photographs?
Okay, all right. Okay.
Clear about a couple of things.
Go ahead, Jim.
First of all, people can be at this building, and we've told Mr. Grant that. That's not a question. They can go walk their dog. They can be there. That's not, it's a garage. People can be there. I want to be very clear about that. The issue that you are being asked to consider is whether or not somebody is spending the night there on a regular basis. And Mr. Bears testified that based on his photographic evidence that he concludes that somebody is there regularly. This isn't going to the code board because it's not a code enforcement issue. This is a conditional use that's been granted where the statement was that it wasn't going to be used for residents. So I want to be clear about that as well. And again, that the only thing that you're considering is whether or not somebody is spending the night there. We have not seen any evidence of the person that we suspect spending the night there having a primary residence anywhere. We've not seen electric bills from another location, a driver's license stating that he lives in a different location. We haven't seen one that says that this is his primary residence either. So these are things that I would hope that be presented to you today that might, as evidence from Mr. Grant, that might show that he really isn't living there. I want to be fair about what we're doing here. Mr. Hillebrand isn't here in opposition. I think he's here in support of what I'm saying. So I want to make, when Ryan was saying opposition, I want to be clear. I think that his statements, and I'm going to ask him if he wants to come up now to support what our evidence is. And he may be different, but I think that's why he's here.
Okay, okay. Hey, Jim, question. Hang on, let's get through this. Yes. Just real quick, are you here in support of what Jim and Adam have presented to us? Yes. And you are here to show evidence in support of that?
To support, to show, except for what everyone in our community sees and deals with on a continuing basis at this property.
Okay, all right, go ahead. Let me get you to raise your right hand and be sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
And state your name and address, please.
1104 Riverside Drive, Prospect, Kentucky.
All right, Bill.
31 years now. I've been blessed, if you can call it that, with the presidency of the Homeowners Association. So I get all the phone calls anytime anything happens on the street. Quite a few of those phone calls have been about this garage. People walking their dogs and being accosted by the person that is living in that garage. Look, you can look back at police records probably to help determine the times that the police have been called down there to establish that he is, that he is there pretty much all the time, except when he's at work. We have, I personally have never had a situation with the person living there. Okay, I've never had an issue with the man.
All right, and hang on, Bill, let me stop you real quick. As far as, I'm not interested in personal relationships with neighbors and whatnot. Again, if it's in support of somebody living out of the garage, and when you said that police reports could justify that, that comment is relevant. So,
I drive, when I leave for work in the mornings and when I come home in the evenings, I make a point of driving that way quite often, and I see a car there in the mornings, and I see one there in the evenings.
yeah. All right, thank you, Bill. Adam, do you guys have anything else?
I believe that's it. It's pretty simple. We're just here again in relation to the conditional use that was approved. It did not include use of the garage as for living.
Let me get you to speak into the mic if you have something to say here.
Yeah, let me ask you a question if you don't mind. Report, you've indicated that you all had Mr. Grant come and sit down with you and the code enforcement officer. And it appears from what I'm reading here that he acknowledged that this was taking place. Asked for time to correct this situation.
Well, you can ask him whether he acknowledged it or not. You know, I said earlier, Mr. Grant has always responded to our phone calls. He's come in, we've talked several times.
Wrote here, somebody wrote this.
Yep. Well, that's the summary of our discussions, yes.
Used it, sir. Or did he not acknowledge that his son was living there?
In my opinion, yes. During our discussions, yes. That's why we're here. What I wrote. Mm-hmm.
All right. Okay, thank you, Jim. Don, could I have you come forward, please? Could I have you come forward, please, to the lectern? And if I can get you to raise your right hand, be sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
And could you discuss what you heard? Can you discuss your defense and what you heard there? Yes. Yeah. Yeah.
I didn't realize this is where I was going to be in this setting or whatever. Or I may have needed to call an attorney. I just like to make that statement to start with. I asked Mr. Ryan when I was told to speak through him. I couldn't talk to Mr. Urban or Mr. Adams, and called him, and I was told to ask him questions if I had any. I told him I didn't know what questions to ask.
Mm-hmm.
And he said he couldn't advise me, but he would answer any questions. That was the extent of our relationship. I just like to make that statement. So I didn't realize what the setting would be, so I came in here like I am right now. But I'm ready to respond to this stuff.
Okay. Well, let me go ahead and hear the response. And
I'll need those pictures. I'll need to bring him back up and somebody to work the thing.
okay. Yeah. I did get one ended. State his name and address.
This will be slow because I've been going this in my head for the last 3 weeks.
I understand. Real quick, Don. You did get sworn in, but go ahead and state your name and address for the record.
306 Twinbrook Drive, Shepherdsville, Kentucky.
All right. Thank you, Donald. If you want to.
I'm nervous. I'm sorry. It's to be a little bit slow. I'll just work off the pictures. If somebody can bring the pictures. That picture's totally wrong. That picture didn't happen either.
Donald, what do you mean it didn't happen?
None of those pictures didn't happen.
If you could talk clearly into the mic. You might have to move the mic around. Yeah, there you go. And when you said that it didn't happen, I don't understand.
The time stamp and date, those pictures did not happen. My grandson was in Daytona Beach with me and my wife on that date. That's his, I'll agree. I can't tell what that truck, who that truck belongs to. You can't tell, but just for conversation, you can't tell what truck that is, whose truck that is. It could be somebody else backing in my driveway in the dark. But I'll agree that that's my grandson's truck. That red Ranger pickup truck is what my grandson drives. He was in Daytona Beach on 7/31/22. We have a timeshare down there. We go every year, and we left. My brother-in-law died on the 29th. We left on the 30th and got into Daytona Beach that Saturday night. He was in Daytona Beach in the condo at the time these pictures supposedly depict his truck moving around in that driveway. So the pictures are all wrong. What they're doing with these pictures, I have no idea. So every one of these pictures he just showed are not correct. Now, just starting with his pictures. Why this is going on, I don't know. Me and Jim settled this, it was about 3 years ago, with Mr. Townsend, Adam's predecessor. Complaints have been made by a lot of people. We were friends when I lived up there. The man had just supported his, whatever. I'm nervous. But the complaints are being made. I'll get jumbled on this. But the pictures are all wrong. Timestamp and date are all wrong. That was my grandson, if I could make this thing work. That's my grandson there. That is my grandson walking the dog. Timestamp and date is totally wrong. Using these pictures to try to say that my son is living there is wrong. My son does not live there. He lives at 306 Twin Brook Drive. I've got his driver's license. Jim and them, they're supposed to investigate in these complaints. A complaint is a complaint. The complainant, Mr. Townsend, invested the complainants along with the complaints. Mr. Urban and him walked through the garage. After this thing was, after he took it to the point of having this meeting here, I called, a couple weeks into it and talked to Mr. Fisher and asked him to ask Mr. Urban, if he could ask Mr. Urban and him to walk through the garage like they did before, and before they had to bring it in front of this committee and settle this, like him and Mr. Townsend did before. You can walk through my garage. upstairs, downstairs, and see that it is a garage. The upstairs is for storage. The downstairs is for, I've got boats, I've got golf carts, I've got motorcycles. My son works on his trucks in there, and all my grandsons. That's what the garage is used for. Not living in there. And Mr. Urban agreed with me and told my son the same thing. And I used the garage, I used the garage when I lived there. It was built because I built the house back in '79, before before you had to build above the floodplain. So naturally, my house flooded on average every 3 years. I built the garage to put my furniture and stuff in. The second floor was for furniture and what I had to move out of my house during the flood and a higher level. So it's built for storage, the upstairs. That's what I use it for. It's still got a lot of my furnishings, my grandson's furnishing, my other grandson's furnishings. Everything's still in there. Used for storage, not for living. He could see that there's not been anything changed in a board or anything built since he okayed it when I built it, since they walked through it with Mr. Townsend. And I tried to get him to come do it before this came to this extreme. And he refused to do it. He wanted it to come before you all. I don't know why. In my opinion, it's going to be settled by somebody walking through the building and see nobody lives there, and nothing's been changed. Statements that the witness come up here and said, police records. The same complainants, I'm sure, that are making these complaints, if you'd investigated the people making the complaints before he took the complaints and got on me, they took my son to court over my grandson firing a shotgun during hunting season and said they were shooting, my son was shooting at them back in the woods when my grandson was shooting at a 5-gallon bucket behind my garage up there while my son was cutting grass. He had to go defend himself over that. Same people complaining about my son living there. He brought the records, police records about my son being up there all the time into this a while ago.
Don, let me
He brought it up.
let me ask you real quick, and I know you're nervous, but first of all, let me try to explain what we're doing and the outcome of what today, what the decision could be.
That's what I'm concerned about. The outcome is what I'm concerned about.
I understand. So this whole case is you were granted a conditional use permit where the condition was set that it could not be used for living space. Complaints have been filed that there is somebody living there. And what's before this board today is what do we do with that conditional use permit that was granted at the time, now that complaints have been filed, that the conditions are not being met. Evidence has been presented in support of that. And in our packet, let me read this to you. And this is a timeline that code enforcement did lay out. Our counsel, Tate, just mentioned it, but I want to read it to you. September 27th, Don Grant came into the office to discuss 1515 Riverside Drive. Jim Urban and I sat down to discuss what was going to be done and informed Don that the case was going to proceed and be heard by the Oldham County Board of Adjustments, that's us, based off the evidence that had been collected. Once again, Don stated that his son was not living on the property. I informed him what I had observed in the pictures, which I had him presented, and based off that, what I had concluded that it appeared that it was. Don asked what could be done to avoid having a hearing, and Jim told him to tell his son to move out. Don asked for 1 week to get things in order. We agreed.
I've got this all written down. I've got a folder full of this. It would take me reading it to same thing. That meeting was a happenstance. I came in there to get my certificate of the permit that I got to build a garage. In 18, I was all caught up in trying to sell the property, 1512, to FEMA. I forgot to get the certificate that I had hanging inside the garage that I got from Jim Urban to build the garage. It floated off in the flood because it was a high-level flood. He reminded me of this, and I wanted to have that certificate involved, just to have it. I'd lost it. So I was up there, I went up there to his, I didn't know it was his office, went up there to get a copy of that certificate, and I was standing there, and the lady that, his receptionist, whoever, she's the one that I ended up having to go in there and talk to. His office is right back in there. And I was waiting on her to print that certificate up for me, all the rules and regulations of it, so I could read it. And he happened to come out with an associate that he was talking to and asked me if I could wait till he got done. He was walking the guy out, and I said, sure. So he didn't ask me to come in. I didn't come in to see him. We just met there. So he asked me if I could wait a minute. So we were talking, and he let me know. And he said, well, I'm going to leave him up a little longer, and we'll decide what we're going to do. I expected another meeting before anything like this happened. He wrote it up like that was a meeting called, making a decision to do something. Well, I'm waiting on a phone call to get another last meeting before this happened, and it didn't happen. I received a letter to come in here. He wrote that wrong, and I don't mind saying that to you. You want to say something?
Don, let me ask you, has anybody been living on the property? Never.
He said that, I'm sorry, he said while Mr. Townsend was in this, he told me one time, I understand somebody's staying there overnight occasionally. So somebody's staying there overnight, my son's staying there overnight occasionally, that has happened. He does not live there. I have a list of.
And what is occasionally? How often is he living there?
He rebuilt an engine for his truck one time, and I don't worry any of you mechanically, fool with a car or anything. That's a long process. You have to stay with things at a time, and to drive, just so he doesn't stay overnight continuously, to drive from Prospect to Shepherdsville, so there's a 40-minute drive at least. So to leave there at 1:30 in the morning, to be sure.
Was living there while he was fixing the car.
Times.
Is there water?
No.
There's no water in the garage?
Water permit. There's no facilities for a sink, toilet, or nothing because you don't have any water. There's nothing to indicate.
Is there electricity?
Yes, you have to have electricity.
Electricity, but no water.
Electricity, no gas, no water, nothing. It was built for a garage. Signed off on it when I built it, signed off on it again with Mr. Townsend, and he'd sign off on it again if it wasn't Don Grant, with David Grant involved. The people don't like David.
So you were saying that your son was living there while he was fixing his car? He was
lived there.
While he was fixing his car?
He stayed overnight, I'm saying.
Okay, all right, so he stayed over. How long did it take him to do that, to fix his car? How long was he staying overnight?
Rebuilding engines over days or weeks. But I'm saying I use that as an example. He may have stayed overnight one time there. I've had people pull campers up there at a party weekend from the New Albany Boat Club. I let people stay in the building rather than let them drive drunk and go home. People do that up there all the time. There's campers in 7 different yards up there. Mr. Bear knows that. And there's Christmas lights on one of them campers that up there. People are staying in them. I don't make complaints about that stuff. He knows about it anyway. That's not according to regulations. You can't do that.
Okay.
That's the side. That's an aside. He said something about homeowner's policy for 306 Winter Drive. My son pays for it. On his belongings. He's got driver's license. Put it on the overhead.
And then anything that you're showing here does need to be submitted as evidence.
Well, I didn't get his driver's license, but all this stuff's a matter of record. I've said this to Jim. Driver's license, trailer license, boat license, his income tax comes there, Uh, uh, Anything, everything that I got in my name comes to my house. Everything in his name comes to my house. 306 Twin Brook Drive. That's where the man lives. They could find out. All they have to do is pull up his driver's license, his truck license, his boat license, his trailer license.
Well, it's different what's on your license versus where you're living, and that's what's being presented today is somebody's living there. And what you're saying is nobody is living there.
Living there.
People have stayed there overnight. Your son did over the years, your son did while rebuilding an engine that could have taken multiple days, but not living there. But what is multiple days? Are we talking a week, 2 weeks, a month?
And he stayed there for a week. Maybe one night he stayed overnight before driving home and going back. Maybe a Friday night after work, he stayed there all night long. As an example.
Oh, okay.
His driver's license, or everything's on the, pull up his name, and everything will show he's at 306 Twin Brook Drive. Why would I want to I didn't think I need to bring a copy of government.
All right. All right. I'm just going to ask, I'm sorry to interrupt you, but board members, do you all have anything to add to this? Any questions for Don, or let's stick with Don for now, and we'll bring Jim and Adam back up here shortly.
Don, did you say that your son's residence is in Shepherdsville?
Yeah, 306 Twin Brook Drive. We all lived together since I sold my house.
All live in Shepherdsville.
There's 4 of us, my wife, and my son, my grandson.
I'm sorry, when you were sworn in, was that the address that was?
306 Twin Brook Drive, that's what I told her.
That was a Shepherdsville address.
Shepherdsville. Okay. Mr. Hillebrand brought up a police record. Well, Mr. Smithson's probably one of the complainants. He tried to pull my son out of a pickup truck as he was leaving after cutting the grass up there at the garage to come home. Tried to pull David out of the pickup truck. He calls Jim Urban, and Jim Urban tells him to call the police, and Jim Urban tells me about it. And I said the same thing, call the police. Jim will testify to that. You know, one of the complainants, that's why I said Mr. Bear ought to be investigating the complainants along with the complaints, and he wouldn't be doing this.
Is there anybody here that you wish to call forward in support of you? Okay. Board members, other questions?
I have a question for Mr. Grant. Mr. Grant, so what you're saying, in essence, is that all of these pictures that have been presented are false?
Yes, they're false. I'm sorry. Yes, sir, they're false. My grandson was with me and my wife in Daytona Beach. He was actually, at the times, he was probably asleep. He probably hadn't even got up in the bed in Daytona Beach.
Do you have any property at this place? Any property of your own at this place? Do you have any property in the garage?
My personal property? Yes, I've still got property out of the house that I own there, that I stored up there, that I've got a garage full. I had a 5-bedroom, 3-bath house at 1512 Riverside Drive that I sold to FEMA. And I had a house, me and my wife had a house at 306 Twin Brook Drive that I moved everything into and into the garage at 1515. So the garage is full. I've got some pictures of the garage that.
The only property that you have there? Garage.
I've got 2 golf carts there. I've got some clothing still stored there, and some tools, and the property out of the house on 1512 upstairs, up in the stairs, the second floor of this garage. I've got some of my older grandson's stuff up there that he stored. He actually had some legal problems, and he's still got his stuff there. My other grandson that supposedly was in those pictures, he's got stuff there. He's 20 years old. And, you know, it's a storage building. The upstairs is storage.
You answered my question. So you've answered my question.
Okay, I'm sorry.
You answered my question.
Let me ask over the, let's just say well, hang on, over the that meeting that took place was September. So let's go back and say over the summer months, June. How many days would you say somebody was was spending the night in the garage? The month of June.
I don't know that David stayed there overnight at all there. He may have. He doesn't live there, staying overnight.
In month of July.
I can't say that he did or did not, but he doesn't live there. The point is, he washes his clothes, he eats, and everything you do to live is done at 306. He can't do anything at
Sorry, it's done where?
306,
Shepherdsville.
Shepherdsville.
All right.
There's nothing at 1515 to be able to live. There's no water, and there's no facilities. There's no sinks, there's no toilets, there's no nothing. You have to have water to live. I carry water. He carries water up there in gallon jugs from 306 to water the dog. I've got a watchdog there. Okay, another thing he brought.
1515.
1550.
He carries water. Where does he collect water?
At the house, 306. We put it in gallon jugs. He takes it up there to water the dog. The reason he's there at early morning, and we discussed this, both of them, we all discussed it. Everything we've talked about, we discussed in the three of us. He's going to be there. My son works in Shelbyville. He leaves the house and goes up there, waters the dog, takes the dogs out and let him do his business, and feeds the dog. He's going to be there somewhere between 5, 5:30, and 7 to go to Shelbyville and be able to be on his job. My grandson, they ride together. My grandson works at Hurstman Lane in 64. They ride together or they don't ride together. One car goes in the garage, one of them they ride with. Not all the time. My grandson has a life. He's 20 years old. He stays with friends. He stays at his grandmother's up on Oldham Acres. Either or. Sometimes he walks from the 1515. It's only a block. And stays with his grandmother's.
How many dogs? You've got guard dogs at 1515? Just one?
That's the security with the cameras and whatever. There's problems with the complainants. Not all of them. Some of them. I've had trouble with people getting in my garage, breaking in my garage. I've got a guard dog. I've got security cameras, etc. They're going to be there in the evenings on a regular basis, coming back from Shelbyville to Shepherdsville. They come and feed the dog again, water the dog, let him out. He exercises. He goes back in. Sometimes my son and grandson ride together back to Shepherdsville, and sometimes they drive separate. My grandson goes his way, and my son comes back. It's going to be we talked about it, on a regular basis. You're going to see them early in the morning and in the afternoons when they get off work. Early in the mornings and in the afternoon when they get off work on a daily basis. We talked about this. That's what he's proven with the pictures. Or if he had the right pictures, or if the pictures weren't doctored, sorry about the word. The pictures are wrong. My grandson was in Daytona Beach.
Other questions for Don?
I have a question, Mr. Grant. You built this garage across the street from an existing residence. Do you still own that residence?
I sold that to FEMA in 2018. There was a program. It's still going on. FEMA, because I had so many claims against the insurance, and they're doing it all over the country, and they may still be doing it, that they would buy the property to have them pay the insurance.
Okay.
I took the buyout and sold the property. Most of the people on the beach they would pay to raise the buildings or buy the property.
Okay. All right.
I took to buy the property. So the county owns 1512.
And you still store boats and things there because you want to come up and use the river, or you store boats, or I see jet skis outside. Do you still come up and use the river, or?
My son does, and my grandson. I'm not so much on the river anymore.
I'm just trying to figure out why you still have this garage if you don't have a residence there, and if it's in a floodplain.
I still own it. I'd rather not have it. I've been looking for property big enough to take The property that I have it's a 40 by 50 garage. It holds quite a lot. And I've got quite a lot there. And then the 2-car garage I've got at 306 Twin Brook Drive, I've got it stuffed all the way. I've got the other furniture and a custom car that I got in the garage at 306. It's full. So I want to buy a piece of property big enough to house a nice house for the family and the storage of all the stuff I have. And in the process of finding it, I haven't found it yet. When I do, I'm going to sell a piece of property in Prospect on 1515.
And can you give me an idea, how long have you had a dog staying in that property to protect your property?
Had the dog ever since I moved out of there.
In 2018 or? Okay. So they're coming up every day to take care of that dog?
It's either me or them, and they're helping me. My wife, this is all personal. You know, this gets into your personal life. You know, this setting is totally uncalled for. My wife's had heart trouble.
That's fine.
That's what I'm
I
saying.
just wanted to understand why someone is there. I'm just trying to understand why someone is there daily and the function of the dog and why this is all going on. So
if I would be comfortable waiting for the police to call me and tell me my garage was broken into all the time, and that's not what I want. But if you make a call to the police, they come, and if you can't tell them so-and-so did it and want to take a warrant out for so-and-so, they tell you whenever you find your property, or if you got somebody you want to accuse, they can't do anything about it. And that's just the truth about it. So I could wait for the phone to call and go up there and repair a door.
Let's just keep it focused. We're trying to figure out if somebody's living on the property.
it's fine. Thank you.
All right, thank you, Don. You may take a seat. Adam, if I can have you or Jim, either one of you come forward. I just want Jim.
And I'll sit down.
Yeah, that's fine. Go ahead.
I don't see how this ends without them coming through and looking at the building and see that I've done nothing to make it a living space. It's a storage space. That's all it's in it. And there's no way to live in it. Mm-hmm. That's the way we solved it before when Mr. Townsend was there. And I don't know how it gets solved otherwise.
Okay.
By not even looking at the building, how can we make a decision?
Good. Okay, thank you, Don. Okay, Jim, if you can come forward. And if you want to direct some of the comments toward Adam, feel free. But so you've heard Don. Do you have any comments as to what you heard?
Adam, let me start with what I agree. Don, I've said this in this hearing. Don he's answered the phone. He's been cooperative. I want to make sure that everybody really understands that. We did, when Darrell Townsend was code enforcement officer, we were allowed to go in the building, and we did look and see, and there were no cooking or restroom facilities inside the building. When Adam was down there talking about material that was outside the building, and Adam has been going down Riverside Drive, our code enforcement, we are considering, we do corridors. We don't just go to one property, we try to do corridors. And we have worked with the homeowners association and the property owners to try to get every property into compliance. And granted, there are still some that aren't. But Mr. Grant met with Adam and talked about the material that was out in the property, and some of it actually wasn't even his. It was on the adjoining property owner. When Adam asked, and he will testify, if he could go inside the building, Don said no. Once we started this case, that's when I decided to not have any other communication with him, because I didn't want to make it a negotiation. I think that we had done that over probably about 5 years. In terms of the pictures not being time-stamped correctly, we made sure that they were. The cameras were set up to be the correct date. In your, this is attachment C, and Mr. Grant does have a copy of this. This was the report I sent to everybody, which is 1515 Riverside Drive timeline, where it says July 2022. And these are notes that we made in advance of actually filing the report. It says on or around July 8th, we talked to Don Grant. He asked us if he could wait until he returned from a trip. He was leaving, and we said, sure. On or around July 13, he called. He was back from his trip. The picture was dated July 31st, so I don't know how we can say that it's not at the correct date. And so I just want to make sure that that's clear, that we don't take these investigations lightly, and that we make sure that we're as accurate as we can be, and we document things as best we can. The pictures were properly date and time stamped. In relation to that vehicle leaving, it could have been either his son or grandson that was driving that vehicle. So we didn't say that it was the grandson driving his own vehicle. This is difficult. Again, Don and I have talked when he, and just to be clear, the FEMA grant was one where we actually, FEMA purchased the property through the grant program, and the building, the residence across the street was demolished to get it out of the floodplain. And so we've had a lot of communication, even just during that process of working through FEMA and purchasing the property and moving out, et cetera. So again, he's always been cooperative. So it's difficult. I think the real point is that over the years, we have had many, many discussions about whether his son or grandson is staying there overnight. And that creates the condition that we're here for this morning. Welcome to ask any questions or ask Adam.
Yeah, I've got a couple. And again, this may be directed to Adam. How many complaints? Give me a time frame and how many complaints over a month's time, over the summer months, 5 years. How many complaints have you had about somebody living there?
I would be making up a number at this point so I don't want to answer that, but multiple. Let me just say that. It's not based on one person or one complaint.
Next question. It's
had people who walk on the street, people who live there. We've had a meeting where at least 6 of the property owners on Riverside Drive asked Judge Vogel to meet with us, and we had in the conference room across the hall, we had probably about 15 people involved in a meeting where they were complaining to Judge Vogel.
about somebody living there.
I have a question. As far as I think that one of the things that's confusing me or confusing the issue is the definition of living there. Is living there include spending the night occasionally, or is it because you have your driver's license, or that's your official residence as your address of record, or is it that if someone is staying there on occasion, and whether they're sleeping in a chair or a bed or whatever they're doing, is that considered occupancy? And is that restricted by the conditional use permit?
If you look at the letter in the report dated October 12th to Mr. Grant, which again is part of the report we gave you, in the second paragraph, photographic evidence from this investigation leads us to the conclusion that at least one person has regularly spent the night on the property. That's what I'm saying. Whether living there, what we're saying is regularly spending the night.
Okay, that's what because he's saying that his son has a driver's license that says he's living at 306 Twin, whatever, but yet he acknowledges that he does spend the night occasionally or at whatever period. Okay, so I'm just getting a context of. I think we're all. I'm got the impression everyone's saying the same thing. It's just the definition.
I said earlier when Darrell Townsend and I went in and Mr. Grant allowed us to go in the building, there were no, by definition through the Kentucky Building Code, there were no, the occupancy would not have been considered to be a residence. There were no cooking facilities, no restroom facilities in the property. And those are typically what you see in a residence. Under oath testifying that does not exist. What I'm saying is that from the photographic evidence that Mr. Bear has testified to, his conclusion is that somebody regularly spends the night there.
Okay, thank you.
All right, any other questions for Jim or Adam?
I got two things I want to. Why didn't FEMA buy the garage across the street at the time they bought the house? Because the garage now is in violation of the.
Only the buildings that have residences that have flood insurance are subject to the FEMA grant. So if it's not a residence, you can actually build a building in the floodplain. You can build a house in the floodplain. We've elevated some of those properties. When there's a residence and they're part of the National Flood Insurance Program, and they have regular flood claims, that FEMA has determined that it would be cost-effective to purchase or raise property. So it's only, you can't go raise a garage.
This property has a CUP that has an accessory structure without a primary residence, which is what it is. So that's why it's
That's why I'm asking the question. It's been left.
it's no residence.
Do anything with it?
And it's on a separate property as well. So the FEMA grant only purchased the house on the other side of the street.
Could he convert this garage to a residence?
Yes, if. Number one, it would have to comply, you'd have to get a building permit, of course, and it would have to comply with the FEMA requirements, the flood insurance requirements, that the living space is 2 feet above the base flood elevation.
I would think that'd work across the street, but because there's other residents across the street. But when did you ask to last view the upstairs?
Again, it was back when Mr. Townsend was the code enforcement officer, and I've got to say that's at least about 4, if not 5 years ago.
When did he refuse to let you go up, let someone go up and view it lately?
I don't testify to that. He didn't refuse. He said, I need to check with my son before I let you in there, or something like that. Let Adam, why don't you come up?
In my notes. So it was on June the 29th. So I had sent a courtesy letter to Don regarding some trash, and Don called me and said that it didn't belong to him. And so we met down there on the property. He informed me who the trash belonged to, or the junk. And then that's when we were discussing that. I brought up to him that I was receiving complaints about someone residing at the property. We discussed that for probably 30 to 45 minutes. I sat there and talked to him about that. And towards the end of our conversation, I asked him about going into the property to, make sure that nothing was in there, to, no water or anything like that, that nobody was residing there. And that's when he said he would have to speak to his son, David. And he said he didn't want to let me in until he spoke to his son, David. I said, well, talk to him, get back with me so that I can come in and inspect the inside of the house. And at that point in time, I never heard anything back from him. A few other things, something that, Larry, you brought up earlier. I know Jim has difficulty saying how many people had complained. He's been dealing with this for several years. I've only been the code enforcement officer since January. I can go back and say since January, I've probably received from 7 different people, multiple complaints from those individuals, but it's been approximately 7 different individuals.
People living there.
About someone living at the property. And for the last thing to discuss the videos, so I actually installed the cameras on July the 20th. I went down there on the 24th to pull the first video cards, and when I looked at them, the date stamp and the time was all wrong. So That's when I know when I went back down there and I reset the cameras, I made sure for a fact that the date and the time was exact when I put the cameras back up for the 25th on. That's why I didn't use any of the photos or anything that I had received from when I first installed the cameras from the 20th to the 24th. I just discarded all of those photos because they did have the wrong date and the wrong timestamp. From the 25th on, the time and the date was accurate. Yes, from the 25th on, the pictures that I showed, and I've looked through probably several thousand pictures. What I brought you today is just, just kind of one typical day of what I noticed looking through thousands of pictures. If it didn't have some activity taking place that directly involved 1515 Riverside, I just went over that picture and, just kind of discarded it to save room for more pictures. It was taking pictures nightly because the camera activates anytime there's movement. And if you go late at night, there's a lot of deer and turkey in that area. So it was taking photographs all night long anytime a deer walked in front of it. And you could see the red truck sitting in the spot that I said that it was. And the black truck all night long was in that garage. At no time did it come out in the photographs that I observed. I had multiple photographs where I could see the guy, David, pulling the black truck into the garage and then closing the garage doors. And this may not have been all in one day, but over multiple days. It was the same, the pictures that I showed you was a typical day, and it, I went through at least 5,000 to 6,000 photos.
Okay. Any other questions for Jim? I'll call you back in a minute, Don. Any other questions for Jim or Adam?
Yeah, it says on July 13th, Don called you. You stated earlier that he was back from Florida on that, and you know that for a fact that he was actually back in Kentucky at probably his residence when he called on or around the 13th.
He had asked for a week while he went on his trip, and so that was about a week later when he came back and he called us. And he did what he said. Again, he's always been cooperative.
What are the options to this board today? And if the code enforcement board has no authority to monitor any of this, what is the recourse of the board at this point? Board.
Let's save that for the ending part of this. Well,
I mean,
Mr. Chairman, I don't know if you want to
know where they're going with this. Are we talking about habitation or?
I agree with Jim. We'll discuss that in a minute. All right. Any other questions for Adam or Jim? All right. Don, do you have comments?
You said I was back on the 13th. Is that what we're relating to these pictures?
So I don't know that the dates are important, at least to me. I don't know about the rest of the board. What I care about is if somebody's living out of that place, and we've got pictures, whether the dates are, are the correct, and I assume they are correct. We've been told that, or if they're a week before that. Whatever the dates are is irrelevant to me. It does show somebody was there at that time. It shows trucks moving in and out. It is showing evidence of somebody residing at the place.
Correct him just for between he and I. We're going to talk. We ain't done talking to each other as long as I own the garage. I went to Missouri. I told you I was going to be gone for the weekend. In the 31 date, I was in Daytona Beach. Just so you and I are not at odds. All right. Okay. Okay. The times are of a morning and of an evening. I'm not saying anything different about that. I agree. Like he and I and Adam talked before, the times are going to stay the same as long as the dog's there. Got to be fed in the morning on their way to work, and in the evening on their way home from work. Now, should I have them or ask them to stop someplace and shop or eat, as an example, do something so that the times would change? It makes sense. They're on their way to work. They're going to feed the dog. Both of them on the way to work. The times are consistent. We talked about that. The pictures are showing exactly what we talked about. Before they even set the cameras up, we talked about this. The time is going to be consistent. It has to work that way. They're on their way to work.
Right.
The morning time's going to be consistent. The evening time's going to be consistent. They're on their way home from work. It's going to be consistent. The cameras have proven that. Their camera has done exactly what we talked about. It's proven that. The reason the car goes in the garage, they ride together at times. It doesn't make sense for two vehicles going to the same place and coming back to the same place. Why drive two vehicles? My family, possibly your family would do the same thing. If you're going to the same place, you both jump in the same car. You don't drive two vehicles because you're coming back at the same time. And why leave the car outside when there's room for it inside? They put one car, the other inside. When they don't do that, my grandson's going someplace with his friends or a date or whatever. The pictures are proving life. It's a garage. Use the garage, put the car in the garage. I don't know where I'm making any sense or not.
Don, are you agreeable to having code enforcement go inside the garage? And
I asked them to do it. I've already testified to that.
Okay.
It's no problem.
any other?
That's the only way I see this. It satisfies itself. You look at the building and what it's used for.
Okay. Any other questions for Don? Don, anything else? Oh, go ahead, Charles.
Say that you boys are dealing with this in a consistent time, right? In the morning. Some great time spreads with these pictures. So it's not that consistent to me. I know that there's a regularity about having to be fed in the morning and a regularity about having to be fed at night, but they're not consistent here.
7 to 8 or whatever, it's on the way to work. Am I reading it wrong? I could be reading it wrong. I'm not disputing you, I'm asking.
No, you're not reading wrong.
I'm not reading right, I'm sorry.
I'm just looking at the times. No, myself, I'm looking at the time that they're taking between getting there in the morning and in the afternoon. They're not the same to me.
Go ahead, Jim.
It's 7:15, 7:30, that's not the point, right? I mean,
Okay.
everybody's not they're coming to take care of the dogs, or he's testifying in the morning and in the evening. Whether it's off by an hour, 15 minutes, or that's not really the point. Right?
Okay, I'm good.
Yeah, right, I mean, that's what he was saying.
That's all I'm trying to say is.
Okay.
It is a consistent event that they come to take care of the dogs, period.
I'm just saying they're not living there, and you're saying or whatever. Okay, go ahead.
What we're saying is the vehicles don't move between the time they arrive to take care of the dogs at night and the time they take care of the dogs in the morning. Photographic evidence that the vehicles are still there. And they are activated.
He said he had a multitude of pictures. He only selected the ones he wanted to show. The ones he did show are not correct. Why not show a days full of pictures? The vehicles did leave. I'm saying that vehicles did leave. He's showing them not leaving, but he didn't show them with the pictures.
Right.
The pictures he showed weren't correct. I don't know. I don't mean this to be a controversy. I don't like controversy, but it has to be. You got me in a setting where I have to say, why didn't he show the ones at 9 o'clock or 10 o'clock at night when the vehicles did leave? It's a question.
Right.
Instead of bringing them in, he didn't.
Okay, thank you, Don. Okay, board, unless anybody has further questions for anybody, I want to summarize it and then open up for more discussion or more questions, then I'm going to close the floor. So we have somebody that was given a conditional use permit for a building without residence, with a condition without residence. There's been complaints that there is. Staff is showing that to prove that somebody has been living there at least at times. Don's saying not. So that's what's before us right now is somebody living there, and I think what Tate was saying, or even Jim, it requires for residents requires a kitchen, requires a bedroom, requires a bathroom. Those things don't exist. I am going to make the recommendation that at a minimum, we send code enforcement to take a look and do an assessment. What some of the options that we do have, when conditions are set by this board, if those conditions aren't met, we do have the authority to revoke that CUP, that permit. If that happens, if a permit is revoked by this board, that building becomes an illegal building, or it goes on to code enforcement or somewhere else to determine what happens. But that is an option we have if determined that he is in violation of conditions set at the time of approval. So if we do make the determination that somebody is living there, and per what you said, we're kind of talking about what that definition is. What is living there? If we do make that determination, one thing that option we have at the extreme is to revoke that CUP. Other options, if we do think somebody's staying there excessively and maybe not living there, we can try to put conditions around to help protect the neighbors from nuisance or whatever the complaints might be. Adam has said that we've had at least seven, roughly, different complaints from different people about somebody living here. Again, what's the definition of living? So is somebody staying there excessively? Don is saying, well, we've got dogs. Somebody's there in the morning, somebody's there at night feeding the dogs. Again, the times, the dates, it really doesn't matter. I need to make the determination, is somebody living there? And if just staying overnight excessively, if that constitutes living, that's my determination and your determination. So with that said, I guess, is there any other comments, or does anybody have any questions for either Don or Adam and Jim? If not, I'll close the floor, we'll open up for discussion and go from there. Does anybody want to bring anybody else forward?
So if, in the extreme case, the CUP is revoked, what then are the options? We said there are different options that could be brought forward, but what would
I don't think it's the purview, come on, Jim, but I don't think it's the purview of this board of what happens after it's revoked.
Be real here. Revoking the CUP and requiring them to tear the garage down, I don't think is a reasonable conclusion to this case, quite honestly. I think there are options, and just bear with me for a second. They could come in and get a building permit to construct a single-family residence and make sure that the living space is elevated and convert this garage into an actual house. Somebody can do that. I don't think that Mr. Grant necessarily wants to, but that's an option. The other thing is for this board to place conditions, having heard the testimony. And what are those conditions? Well, that nobody spend the night, or that nobody be there after a certain amount of time. Again, I said earlier, they have the right to be on this property. It's a garage. They can be there to fix cars or go down to the river or whatever use of that property that they might consider. The issue is simply whether somebody is regularly spending the night in the building. So I think the remedy isn't revoke the CUP and make them tear the building down. I think the remedy is the couple of options, and think creatively after this. And Don, if you have any other ideas about what else could happen, put them on the table. I think that it is a matter of whether or not you want to place specific conditions about timing of people being on the property so that it isn't, they aren't spending the night. Or make it a permanent residence, which is an option.
Okay. Board, do you wish to bring anybody else forward? Charles, you good?
I'd like to make a comment. My concern basically is safety of the community, period. There's a lot of conflict about what's going on there, how it's being used, and that concerns me because there's no regularity there. I have trouble believing that everybody is making a total terrible mistake when it comes to being concerned about what's happening down there because as a neighbor, if I lived there, I would probably be concerned. But, and so that's where I'm at with this. Because right now, I'm at only 2 points. And that's rather frustrating. You may have noticed that's why I asked you about what you had there. There was a reason for me asking that. And there was a reason for me asking that. But so, my concern is the community and what the community thinks and feels about that property and how that property is being used. Because they have a right to.
Are we in the discussion?
No, we're not in discussion. I haven't closed the floor yet. Does anybody wish to bring anybody else forward? All right. I'm going to,
No, just stay.
all right, I'm going to close the floor, and now we'll just open it up for general discussion among the board members, and then take a vote from there. So general discussion among board members.
Well, Mr. Grant has admitted that his son has stayed there a number of nights while he was working on a truck. So he acknowledges that someone has been staying there. Whether you want to use the word living or not, they are spending the night in the building. It is not a residence. It is not supposed to have people staying the night. In the way I interpret the definition. And he admits they are, on occasion. I agree with the chairman. Whether the date stamp is right or not, what I'm seeing is an activity on those photographs where the truck comes in, it's there at 10 o'clock at night, and it doesn't leave until morning. And I see a statement from our inspector that says that's the case, and I have to believe that.
Yeah. Charles, to your point, I mean, I look at, a couple of things that we need to consider here. Number one is the community, the safety, the nuisance, the community. The second is the authority of the board. And when we make conditions of approval, this was approved as a CUP, whatever the case number was and whatever date. And when it was approved, the condition was set, no living space. And we have to uphold, that's not a recommendation, it's not no living space. That's a condition of approval. And if that condition is not met, we take it seriously. It's, you're jeopardizing or the authority of the board when we set those conditions. We have to uphold those. Living space to me, and actually by regulation, is kitchen, bathroom, bedroom. That's occupancy. I do like the idea of possibly setting the condition of no overnight. Okay, so fine. The condition was set that no living space, and maybe he's complied with that because there's no bathroom, kitchen, bedroom, but somebody's still living there. All right, fine. So now we set a condition. Nobody spends the night, overnight. Okay, well, we can certainly set that condition. I agree. I don't think we are at a point yet to revoke the permit. I think we send Adam, code enforcement, back out to do an inspection. Is there a living condition? No, there's no living space, no living condition. If the complaints continue to, we can set another condition that says no overnight. And if the complaints still come, maybe at a later date we revoke the CUP. but I don't think we're there yet. And since we are where we are, I do like the idea of nobody spending the night. And now that might be a huge, burden to take care of the dog, but that's my opinion.
I don't know about anybody else, but I also know that it really doesn't take a kitchen sink and stuff like that for somebody to live anywhere. That's a reality. This is not a statement. You can put a bunk bed in there and go to the gas station and use all the facilities there. So you don't have to have those things to violate what we're doing. Just being there overnight as far as I'm concerned, is a violation because you're not supposed to be. And whether or not there's a kitchen sink or anything in there, if they spend the night, they're violating what we started off in the first place with. And that's where I'm at with this.
All right. Is anybody thinking through a motion? If so, do you want to discuss? Or do you want to make the motion? We can discuss what you're thinking about so we can get it out.
If we're going to set stipulations on no one spending the night there, can we set a time frame specifically in the conditions that no one could be there from, say, 12 a.m. to 6 a.m.? Would that be an acceptable condition moving forward?
I mean, I guess maybe before we do this, I need to ask maybe Ryan at this point, or maybe Jim, I know when we set types of conditions similar to this, it does become a burden on planning and zoning trying to uphold some of these things. I mean, you made the suggestion or the recommendation from planning and zoning and not code enforcement, but planning and zoning. The discussion we're having here, are we okay with this? Do you have any comments? Any concerns with this? Go, you, Jim. Incapacity of planning and zoning.
Always enforcing conditions is a requirement. It's actually a requirement under KRS 100. We are required with a conditional use permit to make sure annually that the conditions are enforced or upheld, and have the opportunity in KRS 100 to come back to this board to either revoke or place additional conditions. The difficulty with 12 a.m., 6 a.m., we're not going to be up that time. I am asleep, quite honestly, and so aren't our code enforcement officer, but it will become incumbent upon the owner of the property to make sure that nobody's there.
Well, or do exactly what happened here. Complaints come in, cameras get put up, and then it gets brought before the board again.
Which again, if you choose to put some condition like that, it would at least send a message to Mr. Grant that nobody should be there overnight.
Part of our problem is there's a lot of ambiguity as far as what it means and who's there at what time, and there's a lot of different takes on that. So I think setting a stipulation of a time frame would actually protect us.
I agree.
In the future if there are more complaints.
I've got an issue with saying. I have an issue with setting those times, though. There might be an occasion where I want to work on a truck till 2 in the morning. I'm not spending the night, but I can be there at 2 in the morning. So just to say you can't be there after midnight, I find that an undue restriction of my property. If I want to be there at 4 in the morning to get an early start on something, I think that saying I can't be there until 6 o'clock puts an undue restriction on my property. So I think trying to define it as being no one should stay there overnight. And if we continue to get complaints, and if we occasionally check the photographs and see if anyone is staying there overnight, I don't see how you can go beyond just staying overnight versus you can't be there at 2 in the morning. I have an issue with that.
Well, I guess I'm fine either way. I will say that placing the cameras and doing the investigation that Adam did, it's not easy. It's timely. It's a use of resource. So, we need to take that into consideration. But I think either way we go, whether time or not, if complaints come in, that is going to be the next step. It's, again, setting up the cameras and using county resources. I don't see any other way. I can go either way, whether we put time on there or not.
Well, my thing is, uh, it's all an issue of time. Right now, we're talking about putting some restrictions on when you can be there and when you can't. That's where I'm having the trouble with. The other thing is, and I think that we've missed, is that I'm still thinking safety. That's first and foremost with me always. And I heard during the testimony that somebody was walking the dog and there was a conflict. Now, was the conflict with somebody that was supposed to have been there or somebody who was there? That's my concern. That's a safety, that's a community issue. That's nothing to play with. As far as in these days and times, that's nothing to second guess. Not at all. And that's where my heart is. I don't want to see this gentleman have to have restrictions put on his property. That would offend me. But I think the responsibility is on him to make sure that it's used the way that it's supposed to be used. Period. And that's where I'm at.
So Charles, are you okay if we just say no spending the night on the property?
At this point in time, I think that if another violation comes in, I don't want to put any restrictions on this man at all. That's his property. We've already talked about what he's supposed to be doing, and we should expect him to do that. That's his responsibility as an adult and as a man. But if we get another complaint about it, then we need to deal with it seriously. And whatever we decide, that's what we will do. But at this time, I don't think we should mess with this man and his property, because it's his property. But also, we have to abide by the laws of this land. And we have conditions that he needs to follow that are laws of this land, and that's what I want to see happen. Period. And I want the community to be safe. And he's a part of that if there's issues going on with people passing that property. He needs to square that away.
All right, Gretchen, I guess if you want to continue with your motion, and if you want to, we can either approve or deny your motion, but either you put times on or no times, or continue your thoughts, and then.
I understand your point about, my thinking that there should be a time stipulation was more to set parameters that were set in stone, because nothing about this has been set in stone as far as actual application. I mean, it was in the conditions of the original CUP, but it's clearly not being followed now, because we know, per testimony from both sides, that someone is spending the night there at least occasionally. That is the truth I think that we've come to today. So without putting a time parameter on there, I would like to make a motion. A conditional use permit was issued for the property at 1515 Riverside Drive with the condition that neither floor would be used as a residence. There's been some discrepancy, but since then that it has not been, that stipulation has not been complied with. So we're going to reiterate the condition that at no time may any individual spend the night at the building located at 1515 Riverside Drive, Prospect.
Okay. Okay, do I have a second?
Second that.
Discussion? All in favor signify by saying aye. Aye. And those opposed? Okay, that's been approved. Okay. It's 11:30. Do we need a 5-minute break or keep going? 30?
Appreciate a break.
10:30. That clock is wrong.
Clock is wrong, hadn't been changed.
Looking up there going, holy smokes.
It's taking a long time. I would appreciate a break.
Motion.
I'll make a motion, we take a 5-minute break.
Discussion? All in favor signify by saying aye. Aye. Those opposed, 5-minute break. Okay. I need a motion to come back into session.
I make a motion that we come back into session.
I have a second.
I'll second.
Discussion. All in favor signify by saying aye.
Aye.
Aye. Those opposed? Back in session. Okay. We have 5 more cases. 1, 2, 3, 4, 5 cases. The procedure for these are all going to be the same. Gretchen is going to introduce the application. Ryan, I guess you're going to present all 5 with the staff report. There's going to be a round of questioning by board members to Ryan. When we're done with that, Ryan's going to take a seat. I'm going to call you, the applicant, forward. You're going to come forward, raise your right hand, state your name and address, get sworn in, talk directly into the mic. The mic's being recorded, or we're recording everything. And tell us what you're trying to do, justify your project. You have 20 minutes to do so. Clock is on the wall. When you're done with that, there'll probably be a round of questioning by board members to you, the applicant. And when we're done with that, you may take a seat, and I'll call forward anybody that wishes to speak in favor of the application, and then those opposed. Same thing. Come forward, raise your right hand, get sworn in, state your name and address, tell us why you're in favor, tell us why you're opposed. Round of questioning, you may take a seat, and then I'll open it up for question by the board to anybody. I'll close the floor, open it up for a vote. All right? So with that, Gretchen, do you want to read the next case, please?
Docket OC 22-038, an application has been filed requesting a conditional use permit to allow construction of an accessory structure without a primary structure and a maximum floor area variance for the proposed accessory structure located at 6100 Cherry Lane, Crestwood.
Okay, Ryan?
Thank you. Ryan Fisher, Senior Planner, Oldham County Planning and Development, 100 West Jefferson Street. So as Ms. Chitwood stated, this is for a conditional use permit located at 6100 Cherry Lane. So the application has been filed requesting that conditional use permit to allow the construction of an accessory structure without a primary structure, and then a maximum floor area variance as well. So this is one that, as I was going through it, realized we were going to need a maximum floor area variance as well. So I'll walk you through that. For the proposed accessory structure located at 6100 Cherry Lane in Crestwood. So there's your site information. It is in an R2 residential zoning area. It sits on 1.734 acres. No previous site history. In the case history, we mailed those adjoining property owner notices out on October 31st, and the public notice appeared in the Oldham Era on November 10th. Here is the parcel of land in question. So the applicant actually lives right here at 7017 Cherry Grove. Behind this, they bought this parcel of land and want to put this accessory structure in this general area here. So I just wanted to note that. That'll be on a slide here in a second, but just wanted you to see where the applicant actually resides. Here's a zoomed in version of this property. So Cherry Lane up here on the top of your map. Here's your zoning map showing that it is an R2 zoning area, and the current structures map. So the applicant is requesting a conditional use permit to allow a 1,943 square foot accessory structure to be located on the property without a primary structure, and then a maximum floor area variance to allow the proposed structure to be larger than what our regulations provide in that area, that acreage of greater than 1,800 square feet. So the property once again sits to the rear of the owner's primary residence, 7017 Cherry Grove Lane, and that is in Pewee Valley. The applicant stated in the justification statement that they plan to construct the garage to store vehicles and yard equipment. So section 250-030C, and accessory uses and structures with and without dwelling units, states that they shall follow the principal use. No accessory use or structure may be developed until after the start of the construction of the principal use on the building site, and no accessory use or structure may be used unless the principal use or structure has been developed, except after the review and approval as a conditional use. And then it must be located on the same parcel, except as otherwise permitted elsewhere in the zoning ordinance. Accessory uses and structures shall be located on the same parcel as the associated principal use. So that's why we're here looking for that conditional use permit. Section 250-030B states about the number of accessory structures. So the number of accessory structures over 120 square feet and a total maximum floor area shall be as follows, and this is attached on the back of your staff packet in case you need to look at that. Accessory structures on a parcel size between 1 acre and 2.99 acres, which is what this property falls in between, shall have a maximum total floor area of 1,800 square feet. And there is that chart that you'll find in the back of your staff packet that shows on the size of the parcel 1 to 2.99 acres, it can be a maximum floor area of 1,800 square feet, and they can have up to 2 accessory structures allowed on that property. So the proposed accessory structure, as you saw earlier, is 1,943 square feet. Therefore, the applicant is requesting a 143 square foot maximum floor area variance. So the proposed accessory structure meets the remaining standards of that accessory uses and structures regulation, as well as section 260-030 conditional use standards for accessory structures. Here's the site plan showing where the structure will be placed, and once again, the owner's property would be up in this area. Here are a few pictures, not too many of this one. This is actually coming in off Cherry Lane. Not much you can see goes down a gravel road. Pretty far back off the road is where this will go. And then the applicant actually provided these pictures of the general area where this accessory structure will go. If you look here in the top left, you'll see kind of a slide a little bit and a house. That is actually the owner's property. The applicant will be in that general area to give you an idea of where we're at on that parcel of land. And then just here are a couple construction plans that they provided as well, showing what the accessory structure will look like. Floor plan and some elevation drawings there for you. And another building section. So a couple things here. We have the conditional use permit portion. So the applicant is requesting a conditional use permit to allow the construction of the accessory structure without a primary structure. And the potential conditions for that is the conditional use permit shall only apply to the plan considered here at the November 17th, 2022 Oldham County Board of Adjustments public hearing. There shall be no commercial activity conducted out of the accessory structure, and the accessory structure shall not be occupied as living space. And then the maximum floor area variance, the applicant is requesting that floor area variance to allow the accessory structure to be larger than 1,800 square feet. So you'll see down here, they want it to be 1,943 square feet, so you're looking at a variance of 143 square feet. And then that potential condition of approval, that variance shall only apply to the application and plans considered here at the November 17th, 2022 Oldham County Board of Adjustments public hearing. And with that, that concludes that presentation. If you have any questions, me or Mr. Urban will entertain them. Yes.
Ryan, if you go back to the photo of the site, right here.
Gosh, what happened? Let's do this. Hold on just a second. Having some computer difficulties here. With you, sir.
I'm on my house.
Can I open it back up?
Thanks, Jay. Okay.
With that one? Okay.
Is this a current photograph or is this an older photograph?
I don't know when these GIS, this comes off our GIS mapping software, so.
Okay. My question is, and you're saying that there are no facilities. What are these things I'm seeing on this property? Are they there?
Here's that these were trailers. The applicant may be able to answer that more accurately for you. These were, it looks like trailers that were located on that property at one point. And Mr. Urban said 2019.
Okay. And is there not an option to turn these two parcels into one?
Option, you would have to ask the applicant whether or not they're willing to do that or not. That is an option, though.
What the pricing difference is, but I'm curious as to, that way you wouldn't need a conditional use permit if you had one piece of property.
For any variance,
Right.
size-wise or anything, so.
Ask them that.
Okay, thank you.
Questions for Ryan? Thanks, Ryan. All right, if we can have the applicant come forward. Good morning. If I can get you to be sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
And state your name and address, please.
Hill, 7017 Cherry Grove Lane, Pee Wee Valley.
Sorry, I didn't catch your name.
Norm
Gill. Okay, Norm. Thank you. And if you can go ahead and justify your project.
Yes, so as stated, I do own the property at 7017.
Have an issue?
Is this a LLC?
Created a little LLC to own this piece of property, yes.
Okay.
Scott Lund.
My general contractor.
Okay, he's the applicant in this case, not Mr. Gill. Is that correct?
Well, but besides that,
Any corporation needs their legal counsel to present the case. I probably wouldn't advise of that early on.
well, no, I don't think so. Hang on. I didn't see that it was a corporation.
The application doesn't have Scott Lund.
Yeah.
Treehouse Ventures LLC is the owner of the property. Needs to be the property owner.
If a person is going to subdivide a piece of property and they're considering submitting a subdivision plan, the applicant signs the application. I mean, the owner signs the application, but the applicant could be somebody completely different, and they're doing their due diligence. So, again, we looked at who the applicant was, and it said Scott Lund. It did not say incorporated or corporation or whatever. So I'm sorry if.
Speak into the microphone, please.
Every applicant, you could just forget about having an attorney present on a property that's owned by a corporation by just simply having the applicant come forward. It'd be any individual other that has no relationship to the ownership of the property. Now that's okay if that's your position today.
So the owner of the property is Treehouse Ventures. Is that correct? You're the sole owner of Trails Venture.
Asset of Treehouse Ventures.
Back there, he's a builder.
And Scott, your general contractor, as the applicant. All right, well, all right, go ahead, Norm. Go ahead.
So we built our house in this subdivision in 2017, 2018. I acquired this property here. To answer your question of that was a mobile or a fifth wheel trailer that had been parked there by the gentleman that owns the house there immediately to the left, Mr. John Weiland, who I believe was in front of this board not long ago about the project he had. So that trailer has since moved on to Florida. So it was only there seasonally, and now that I own the property, it's no longer there.
You were,
No other structures on the property. I bought it in order, hopefully, to do this, to get my wife said, my junk out of the garage, and store it in there and do workshop type stuff, personally.
good, Gil, any questions?
Going back to my question of why don't you just take the two pieces of property and make them into one?
A couple reasons. One being, technically speaking, that's the property boundary line between Pee Wee Valley and Crestwood. My house is in Pee Wee, that property's in Crestwood. Really wasn't excited about maybe paying Pee Wee Valley property taxes, but that's neither here nor there. The main reason is I don't know the history of this property. I've done significant cleanup and have continued to with some junk. And I think this used to be a part of a dairy farm. In fact, I used to milk cows when I was a kid on this farm. And I don't know the history of it, so just out of pure security, not only did I really not want to combine it with my residence from a liability standpoint, equally why I formed a little LLC to own it, just to give me a...
LLC only owns this piece of property, not your residence.
Oh, sorry, I didn't catch the last thing you said there.
My daughter and I built a small tree house on it.
I was paying attention to this. It looks like I'm seeing two structures. One might be a small shed, but the larger of the two is a trailer that's no longer there. Is that correct? And I'm talking about the two that are off Cherry Lane. What is the smaller structure? Might even be a car.
Be a car. There's
nothing there.
Nothing there. There's no other structures on this property.
All right. I think you heard Ryan when he presented this, that potential conditions of approval is no commercial space and no living space. And you just heard an hour and a half of...
Not be living there. However you want to define it. I would like to go in there. I probably won't be in there from midnight to 6 either, but...
So I'm still not clear to your question though. I understand one's in Pee Wee, one's in Crestwood, and I'm sure that creates all kinds of complications. But that is the main reason why you don't see that line is...
I don't know the history of the property. And let's start digging footers, and all of a sudden, backhoe pulls up a green barrel or something that causes some issue. I don't know that to be the fact, but I'm just being cautious. I am a businessman, and just to have a veil of protection should something arise on that property, it's not attached to my residence property and puts that in harm's way.
The on the adjacent property. Yeah, thank you. Go the other direction. Yeah, that right there. What is that?
Barn that is owned by John Weiland. This is John Weiland's primary residence. So he used to own this whole this track, and this kind of odd, funky trapezoid-looking property. That was all one piece of property, about 6.2 acres. And after he and I came to terms to purchase this, I think he initially came in front of planning and zoning and Jim, you may recall this one way or the other. I think he came in trying to simply cordon this property off at 2 acres that would be landlocked and sell it to me. And someone ruled, planning and zoning ruled, that no, we will not allow for landlocked land to be replatted. You have to have access to it. And thus this, we call it a flagpole, thus this drive was dedicated going out to Cherry Lane, thus making it not landlocked anymore. I will tell you that cost me a lot of money because it's now not a little landlocked piece of property that I could purchase. It's now a buildable lot, which John realized, and so the price of poker went up significantly. But I did buy it and now have access out to Cherry. His drive actually is on this same, that I have a into perpetuity easement given to him so he can access it to get to his house or whomever may own that house. So that's kind of the history of how it got divided the way it did.
Can you tell me the purpose of this? Are you calling it a garage?
Yeah, a garage and outbuilding. I've got a small tractor. I've got a 1987 Grand Wagoneer Woody. I got a pickup truck. I got a lawnmower that my wife hits her shins on in the garage. So it's just to put stuff in that we don't have room. And more than you care. Now, I grew up 1,000 feet away from here on the corner of Rebel and Cherry, and my mom lived until she passed away in April, right down here on Cherry Lane. And my dad had a 2,400 square foot barn that I've got a bunch of stuff into. And she passed away, and we're having to sell that, and I need a place for my stuff/junk.
And what is your proposed access to it? Access to it? To the garage?
Cherry here.
I understand that. Is there gonna be a driveway? Oh, it's off of Cherry, good enough. Are you gonna build a driveway or gravel or anything, or is it just?
Gravel drive off of Cherry, back here, and then the building sits approximately right here.
Okay. And how far is that from the barn that's over there, that we pointed to a second ago? No?
Far as the drive?
No, the proposed.
Building?
Yeah, the proposed building.
Right in here.
And can you give me a guesstimate?
Here, there's a slide here somewhere. So this is oriented 180 degrees. So Cherry Lane's down here, so you come up the drive, and it kind of sits in the middle of the property.
Okay.
My house is I'll put a little walking path out of my house back to here. Any vehicular business would go out and out to Cherry Lane.
Any other questions for Mr. Gill?
I don't know if this is appropriate. I'm just curious, why this floor plan? Doesn't seem very efficient.
Mature trees that I wanted to save. Won't classify myself as a tree hugger, but if I don't have to cut it down, I don't want to cut it down. I kind of grew up in the woods and want to preserve them. So it's got two garage doors. You'll actually drive in, and this will be a slab of concrete right in the L, if you will, and be able to go into this garage or this garage.
Okay, no, I appreciate that. Thank you.
Big, huge poplar trees that I just didn't want to take down.
Any other questions for Mr. Gill?
Any money.
But maybe your builder suggested this.
Scott will attest that I draw them and he builds them, and so it's my
Okay.
fault.
All right.
All right, questions?
Floor plan, the reason you need the extra 140 odd square feet?
I wanted to be able to pull, vehicles into any of the 4 bays, and it needed to be X deep because of the depth. It ended up, I didn't know that was a provision until we turned it in. So we drew it to put the stuff that I need to put into it, and then we found, and it happened to come to 1,943 square feet. I didn't do that on purpose, that's just what it added up to. And then only when we went in to make application did that element come up that exceeds the 1,800 square feet.
So what would cutting it by 143 feet, what would that do? So that at least that would be in compliance with the regulation. What would that do? It would cut it 143 feet. That's what it would do.
It,
Were to change the floor plan and you know, offset the building a little bit and maybe overlap it, you could avoid that second motion, that second,
becomes a point of contention, I will,
just looking at the floor plan. And I respect the whole saving the trees there, that's great, and then that was a good question, because I was wondering that myself. But it looks like the floor plan could be altered, and then that, second application for the extension of the square footage wouldn't necessarily be.
Are you indicating that changing the square footage would reduce the utility of your building? Okay. I think that's his point. You can't fully utilize the bays if you don't have this extra square footage.
All right, any other questions? Thank you, Mr. Gill. You may take a seat. Is there anybody here wishing to speak in favor of the application? Opposed to the application? Board questions for anybody in the audience?
No, I'm good.
Okay, I'm going to close the floor, open it up for general discussion among board members. I mean, for me, it looks, pretty cut and dry. I don't know that I'm okay with the explanation we got why we don't consolidate the two lots, but okay. I definitely understand that, one being a one county or a Pee Wee Valley, the other in Crestwood, I'm sure has a lot of complications, but other than that, I'm okay with the application. I'm okay with both, the size and the CUP on it.
I'd concur.
Yes.
All right, I'm ready for a motion. Let's do the CUP first.
Okay. I'll make a motion. Motion to approve the application that is filed requesting the conditional use permit to allow construction of an accessory structure without a primary structure. The character and objectives of the proposed use and the potential impact on the community and its surroundings are appropriate. Conditions of approval. The conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing. There are two other conditions on there that weren't mentioned that I would like to actually include in that. There shall be no commercial activity conducted out of the accessory structure, and the accessory structure shall not be occupied as a living space. That was my motion.
Thank you. Do I have a second?
Second.
Discussion? Okay, and I guess all in favor signify by saying aye. Aye. Those opposed? Okay, that one's been approved. And if we want to go to the next one?
Motion to approve a maximum floor area variance for the proposed accessory structure located at 6100. The additional square footage appears to be necessary to limit the impact on the area where it's being built and accommodate the proposed usage of that building. Again, the conditions of approval are that the permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing.
All right, do I have a second?
I'll second.
Discussion? All in favor signify by saying aye.
Aye.
Those opposed? It's been approved. All right, Gretchen, you want to read the next one?
Docket OC 22-039, an application has been filed requesting a conditional use permit for a home occupation personal training located at 4802 West Highway 22, Crestwood.
Once again, Ryan Fisher, Oldham County Planning and Development Senior Planner. So this is a conditional use permit for a home occupation. Applicant is requesting a conditional use permit for a home occupation personal training on property located at 4802 West Highway 22 in Crestwood. Site information, it sits in an R2 residential area, 0.792 acres. No previous site history and case history. The adjoining property owners were mailed notices on October 31st, and the public notice appeared in the Oldham Era on the 10th of November. Here's the piece of property in question, and a zoomed in and slightly blurrier version of the property. Here is your zoning map showing it is in an R2 residential area. And the current structures on the map, as you see, the primary residence, and then what is going to be this pole barn that will be in question here today. So the applicant is requesting I made a typo there, I'm sorry for that. Not auto detailing. So the applicant is requesting a conditional use permit to allow a home occupation of personal training. The applicant resides at 4802 West Highway 22 and would like to offer small group personal training in the 40 by 50 2,000 square foot existing pole barn located behind the primary residence. So just to be clear, not auto detailing, personal training. So section 260-230 home occupation states that a home occupation is an accessory use which is incidental to the use of the dwelling for residential purposes. All home occupations located in residential zoning districts must meet the standards listed in this section. Applications for home occupations must seek either a conditional use permit from the Board of Adjustments or a home occupation permit from the administrator. This one didn't comply with what would be required to be able to get a home occupation permit just reviewed at the staff level, so that's why we're here today. So section 260-230 home occupations number 2, accessory structures, states that offices or studios are permitted within an enclosed accessory structure provided the accessory structure is used solely for administrative or artistic activities of a commercial nature by an occupant of a residence located on the same lot as such building. 260-230 home occupations number 3, activities and products, state no other goods, products, or commodities bought for the express purpose of resale shall be sold at retail or wholesale on the premises, nor shall such goods or products be stored or displayed on the premises or distributed to other locations. No specialty services, such as, but not limited to, dance instruction, crafts, or music lessons shall be provided for a group larger than 5 persons. According to the applicant, classes are held Monday through Thursday at 5 a.m., 6:20 a.m., 7:20 a.m., 8:30 a.m., and 9:45 a.m. Each session has approximately 5 to 12 people per the applicant. According to the applicant, class times are spaced to ensure there will be no congestion and parking issues. All other sessions are just personal training scheduled with only 1 to 2 people at a time. The applicant, and you'll see in a photo here in a second, has removed a large tree next to the property to provide additional parking for her clients and plans to grade and provide a gravel or paved surface. Upon my visit to the location and in addition to conversation, she has not gone forward with that work yet, pending what happens here today. And then there's a circular driveway in the front of the property. You probably noticed that from the aerial views. You'll see that again here in the photos that are going to allow clients to enter and exit. So enter on one side and exit on the other to eliminate any issues that this traffic pattern is noted here in a picture here in just a second. So the applicant really meets the remaining standards of section 260-230. So they meet the residential building and lot, accessory structures, employee size, resident operator, commercial vehicles, and deliveries. And there's just really 1 or 2 things here on the activities and products that you'll see here in a second. So here is that circular driveway. This is the traffic plan that I was noting. I know this is kind of hard to see because of the color of the photo, but the entry here on this side of the driveway, here's the pole barn, This is the parking that you'll see on either side, and then plan is to circle them around in the front and exit them out onto 22. The applicant has added a privacy fence on, and you'll see here in the photos where this is at, but added a privacy fence that actually matches the adjoining neighborhood, which is Heritage Hills. So here was the pole barn initially when the applicant purchased the property, and this is what it looks like today. So here are some pictures that I took at the property. This one coming in off 22, looking down at the pole barn. There's the fence noted of, which once again matches that neighboring subdivision. A little bit closer view. Apologize, the guy that doesn't know how to park would be me, so don't, and a closer up version of the pole barn garage that is used for the personal training. Here's a view from in front of the house looking back out at 22, where the cars plan to enter. And then a couple pictures here looking down 22. And this being the Heritage Hills, you can see not real clearly, but the fence there that they have running along that subdivision. Here's the driveway in front of the house. Once again, over here would be what the applicant has noted to be the exit. And then the other side of the house, where there's some additional parking. Not sure if on the date in question I took these, if these were actually people that were working out at the time or if they're their personal vehicles. And then here is where that large tree was taken out. Like I said, according to the applicant, they plan to grade and do a surface down to allow for more parking in that area. So conditional use permit application has been filed requesting a conditional use permit for a home occupation, personal training located at 4802 West Highway 22. Potential conditions of approval: the conditional use permit shall only apply to the plan considered here today at the November 17, 2022 Oldham County Board of Adjustments public hearing. No alterations to the external appearance shall be made to change the residential character, including any signage. No on-street parking shall be allowed at any time. No goods, products, or commodities shall be displayed or stored on the premises for the express purpose of resale. And the applicant shall apply for and obtain any required permits and inspections for any work that was performed on the pole barn in question. So with that, I'm going to be gentle at exiting out of this so I don't shut anything down. I'll answer any questions you may have, or Mr. Urban.
Okay. Thank you, Ryan. Questions?
Excuse me, what's probably off the mark, but what's the required side variance for how close that can be to that property line? It looks awfully close.
What could be? What's your question?
The building to the property line.
Accessory structure would have a 5-foot side setback.
Not that we're reviewing that, it just looked awfully close to that. I know there's a fence there, so I guess that must be within 5 feet.
Yeah, I mean, it's
because there's no site history.
accessory? Yeah. Yeah, accessory structure is 5.
Okay.
And yeah, it's probably, well, yeah, it's probably 5. I mean, I was out there, so there's a pretty good space between that, and you can see the fence here to the left, but I didn't take a tape measure out to it either, so.
Is there a sound system involved in this building?
Looking at that. Sorry.
Go back a couple of slides. There's I want to see the driveway. Wait a minute. I want to see there's a driveway that's showing. Well, so right there on the right hand side, closest to the house, there's a car. Yes. What is that directly behind the car? That.
That's.
Okay.
Yeah, that's more fins.
Okay.
You may be able to see it a little bit better in this photo. It was very sunny that day. I apologize. I should have gone on a cloudy day.
All right. Your car is the one that's sticking out.
Yes, I apologize for that.
Parking. 1, 2, 3, 4, 5, 6, 7. Question regarding what I'm going to ask the applicants, but you said 260, 230, 2D, and you actually had a slide for it. So no specialty service such as, but not limited to, distant dance instructions, craft, music lessons shall be provided for groups larger than 5. So I'm reading that no more than 5 people if this falls in that category. But I think you had somewhere where it was 5 to 12 people was what they were asking to do. Again, I'm going to ask the applicant, but that is what's in your application, correct? Okay. Okay. Any other questions for Ryan? All right, thanks, Ryan. And if I can have the applicant come forward. Good morning, afternoon. I don't know.
Auto dealing.
We can get you sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
And state your name and address, please.
It's Ashley Marble, and my address is 4802 West Highway 22, Crestwood, Kentucky.
All right, Ashley, and if you can justify your project, explain what you're trying to do.
Sir, just in full disclosure, the 4 vehicles over there were a rental car, a business car, and our 2 cars because we were transitioning jobs. Okay, so those were not additional parking over there. But thank you for continuing. I can't read, but I can't see you if I keep these on, so here we go. Thank you for allowing me to speak to you today. As we evolve through growth and experiences, our identity changes, and with that, so do our brands and our reasons why we do what we do. The barn at 4802 Highway 22 that I've created is an extension of who I am and what I believe and embody. Since 2007, when I graduated with a degree in exercise science and sports med, my education has evolved, as well as I am no longer the same person I used to be. I started personal training in a dark, run-down, bare-bones facility, training people mostly for vanity. In 2009, I was no longer a college athlete, and I did not know who I was outside of a team sport. Sports had been the foundation. I found my worth, and without the community and support, I found myself in a very dark place, overweight, battling depression and anxiety, lost sense of purpose, but mostly alone. And it was in that moment that I thought, how many other men and women feel just like me? How many other men and women need a tribe and a community to help support them and give them a sense of belonging to finish and get through life's toughest battles? In 2017, I became a single mom of 2 under 2. And at that time, I had the strong urge to do more, be more for myself, my babies, and my community. I wanted to show that my babies that no matter what your dreams are, you are possible. Therefore, your dreams are possible with hard work, commitment, courage, and grit. Since that moment, I had hustled for my worth. I'd worked relentlessly, tirelessly, and nonstop to make a future that would not only impact my community, my friends, but also a sense of pride for my kids. The past several years, I have opened one of the largest gyms, most successful gyms in the country. I have ruptured my patella tendon. I have risked it all to open my own commercial business to now where I'm simply personal training out of my barn. What happened is we were at 375 members when I opened at Forest Springs Nutrition, or Forest Springs Complex. And in May this year, we were up for a 3-year lease. My landlord at that time wanted to increase my rent. The problem was we were open 6 months, and 6 months after opening, we were shut down for 6 months. Financially, that was devastating and something I could never recover from. In May this year, I was faced with a choice. My landlord wanted to increase my rent, and I was unable to continue. I had 3 choices. I could sell, I could let go of it and file bankruptcy, or I could relocate. As I received an offer to sell, however lucrative and financially freeing, I wept. There was no way that I could give up my passion and craft for money. I invest my heart and soul into my clients, and I love them as family. I know their pride, their joys, their sorrow, their hurt, their pain, their struggles, their fears, and it is a role that I'm honored to do, to walk alongside anyone during life's toughest challenges is the greatest gift I can be honored with. I knew I could not sell, so even though financially I'd be free, my soul would be lost again. And that's how I landed up at 4802 West Highway. When we saw the listing, we were just looking for a piece of property with no HOA that was on a road that businesses were on that had a different entry and exit, with either a space to build or a barn. And that's how we fell upon this. And when my realtor and I went and spoke with the seller, who is also the realtor, he had marketed it as a 2,000 square foot commercial barn. And when I spoke to him, he told me that he had come to Oldham County Planning and Zoning and it had been permitted and approved to build there. I'm a first-time home buyer, so I was like, awesome, sounds great. And I took the major risk to not only buy the home, but build out over 1,000 hours on that barn. I let go of my commercial business. I sold over 21 pieces of equipment and more than 2/3 of my property. I feel like this is a blessing and a gift from God to be able to continue on a small scale to impact even more than ever. Fitness is a platform that I use to help empower, inspire, and encourage clients to find their worth, their strength, and their courage to sometimes just make it through another day. If it were about bicep curls and weight loss, it wouldn't inspire me. But this barn is a place where they call home, a sense of freedom, connection, acceptance, and a place where they have seen, heard, and valued. In just the last several weeks, I have helped people grieve the loss of mothers, fathers, sisters, husbands, babies, and divorce. I've walked along 2 women since I've opened who have suffered multiple miscarriages that have finally and successfully conceived. I help women and men battle kidney and heart disease, scleroderma, multiple sclerosis. Sorry, she's right there. That's why it's and other chronic diseases. They fight depression, anxiety, insomnia, lack of self-esteem, and worth. Kentucky and Oldham County has given me and blessed me to live the ultimate American dream. Regardless that I grew up in a town of less than 200 people in Maine, where graduating high school was an accolade and mental and physical health was foreign, that no matter what we are born, where we are born, or what class we are born into, we can attain our own version of success in a society to which upward mobility is possible to everyone. The American dream is believed to be achieved through sacrifice, risk-taking, and hard work, rather than by chance. And I must add, a lot of help from God. This truly is not only my dream to be able to provide for my clients, but allows me to financially take care of my 2 babies and be active in their school in my community. Being raised in a small town, your neighbors in town are your top priority. When I go home, we wave to everybody. It matters, and I still hold these morals today. July 6th, we closed on the house, and in the facility, I know that we do have neighbors, so I had spray foam put all over the ceiling, on the sides, on the base, that will help with noise cancellations. We had panels put up on just under or above the spray foam to add for noise cancellation, as well as R13. With the parking, I had removed a tree until all of a sudden, Mr. Ryan and I had a conversation, and I have not gone through with that because that is financially pretty hefty, but that is something that I'd like to do, to grade it out, to level it, to tar it. The fence I had custom built. It was a $6,500 custom built fence to match Heritage Hills community so that we blend in and we don't stand out. And that one piece that you are looking at is just to close it off so you don't see all the cars. And I do know that I think there was an initial issue of traffic, but I am confident that that issue has been resolved for safety. I mean, I have 2 little kids. They go to school just down the road, and making sure that everybody is safe can enter and exit on time. I moved classes so that there is session time, so that there is more of a gap. I have small numbers, and I mean, 5 to 12 is what is the maximum, but very rarely do we ever have 12 in there. They will have assigned parking spots with the build out. If I'm allowed to continue when we gravel and pave, there'll be assigned parking spots, and there will be a traffic flow pattern. One of those things is, as I'm training them individually, I'm also very aware of the time, and I take sole responsibility to make sure that their training session ends on time, they exit before anybody else would come in. In closing, I want you to understand that yes, this may be fitness. Maybe you think bicep curls and squats, but to me, I'm helping save lives as well as my own. And I'm helping the women and men of the community be the best they can be. My clients are breast cancer survivors, veterans, project managers, attorneys, teachers, counselors, psychiatrists, nurses, special education directors, and philanthropists and more. But most of all, they are moms and dads, their sisters and brothers, their daughters and sons, their wives and husbands, and even widows that need a little extra help, assistance to get through. I pray that the business, friendship, knowledge, and empowerment that I provide will be allowed to continue the way we started and not be restricted to 5. If blessed, I will build out the parking lot to make things even neater, safer, and easier for traffic. Thank you to those who are here for being a part of this community, and I hope to continue to empower every single member of this community to find beauty in their strength, to live to their fullest potential, and find joy in life's toughest battles. And I do have, I have a lot. I won't give you a lot. I know it, but this is. Right? How do I use this? Sorry. This is from my the neighbor, where you were saying that looks like it's closed. Oh, did I just do that? Oh, okay, cool. Thank you. Okay, that's from my adjoining neighbor. So where the barn is, he's right here. His name's Jason. And as you can see, he says we have not been impacted by any noise or lighting from the property and have not had any negative issues. Ashley Marble has stopped by on multiple occasions to make sure there were no negative impact, and I am sure they have not. Even before I went to do the fence, I wanted to make sure that he was okay with it and that he thought it was a wonderful idea. So I didn't know I couldn't paint it, so it's not until the spring that it will be the same color. This here is Mr. Stess. It's somebody that I've worked with for over a part of a decade. And one of the things, it says that Ashley pushes her clients in the gym, not letting us cheat or give up on ourselves, but also encourage us to think of ourselves for better and healthier and worthier, and helped him to see. That's not easy to see, sorry. This one here is important because this is a lady, my oldest client in my gym, and she has scleroderma, and she has tremendous physical limitations to where her hands will no longer open, her body is basically becoming brittle. And she said the individual attention allows me to have huge strides in my strength, encouraging me, helping me adjust equipment my hands can't adjust, overlooking my weaknesses and celebrating my victories. As the oldest member of this group with aforementioned issues, it would easily to feel discouraged or to question my abilities. This has given me the confidence I've never had before. It's carried into the rest of my life and relationships. Anyone with chronic illness knows that confidence is instrumental. This one here is the sweet lady that is sitting behind me. I can't look at her or I will lose it. Sorry. But Barb is a retired industrial engineer from UPS. She's also a breast cancer survivor. She says, I came to the barn with a broken spirit, battling depression and anxiety, coupled with the loss of family members from COVID-19 and many health challenges, multiple sclerosis, chronic fatigue, inflammation, osteoporosis, and obesity. The unmeasurable support that Ms. Marble has provided at the barn has been a lifesaver. And I'll leave these unless you want me to continue, because I can, but this one is actually a physician. And I didn't, when I read this last night, this is exactly why I stand before you and fight and ask for your blessing to continue to do this. She said, the barn has been instrumental for my well-being and probably why I am still alive and well today. I'm a physician who has struggled with uncontrolled high blood pressure from age 25. Before meeting you, I had visited many specialists, tried multiple medications without anyone being able to figure out the right combinations of medications to lower my blood pressure. I had gotten to the point where I had come to the conclusion that I would never, I can't see, I'm sorry, my tears, gosh darn it, have normal blood pressure. You may not remember this, but I do. After I'd been working out with you a couple months, I had started having these headaches that I could not make sense of. Lo and behold, my blood pressure had began to normalize to the point that I needed to decrease my medication for the first time in 15 years. The joy and tears that followed when I was told that now my risk of developing long-term cardiovascular complications, strokes, and all the long-term strokes I was told to not stop doing what I'm doing with regards to exercise, as this was the only difference that they could account for this change. I am completely devoted to you in the barn. For me, it has nothing to do with physical or outward changes, but this is my lifeline to keep my blood pressure controlled so that I can be there for my husband, my 4 kids, and all the families that depend on me to keep their children alive and well. You may not know how this one life you have changed, has saved, has gone on to have a ripple effect on so many other lives that have benefited from me being healthy. Sorry, I have tears, man. I love what I do.
Okay. Thank you, Ashley. Any questions for? Yes, yes, yeah, yeah, we need to introduce, what you put on the screen there, we need to introduce into the record. Yep. Thank you. All right, any questions for Ashley?
I have a question. If everything works out for you, you say you're going to be assigning parking spaces and you're going to enlarge your parking area.
Yes, sir.
Foresee any issues now that need to be addressed in terms of safety getting in and out of the area that you're going to be dealing with?
Because I haven't done the parking lot yet, when I halted meeting with Ryan, I actually have cut down the class times right now, the session times. So instead of, I have more of a gap, because right now with the way it is and it's not leveled out and there's not gravel there, it does take a little bit longer to get in, and parking is a little bit harder, but that would be fixed and we wouldn't have any issues with that. But I did change that gap and make sure that people had more time for entry and exit.
Just to be clear, this is active already.
When I bought the house, when I met with Alan, who sold me the house, when he said he had come to Oldham County Planning and Development, that he had gotten a permit for that barn. So I then did everything by the books after that, for my knowledge now. I've never bought a home, mind you, so this was a pretty big step.
Jim, did you have something you wanted to say?
The
Not for the business, but the business is.
And that's what
currently
this
active
is.
And it's in use.
Yes, Jim allowed us, once he came to me, I didn't know. I mean, it was, Adam, is it? Okay, I was in tears. I mean, I was like, man, I've gotten permits, I've gotten approvals, like I've tried to make sure my neighbors are okay. And it was at that time that he told me I just needed to apply for a conditional use permit, and that's how we're here.
That answers that.
I am thankful that he let me continue during that time.
All right, I have a few. You just brought up a question. You mentioned Adam. So was there a complaint filed? Why was Adam there?
Oh, Crestwood Plumbing.
Yeah, go ahead, Brian.
It is my understanding from Adam that there had been calls to him that had been made about cars pulling out onto 22. So she referred to the traffic issue, cars backing out onto 22. So that's where when we talked about her trying to.
Complaints were filed to code enforcement about
I know
cars.
calls were made. I don't know if anything, but yeah, calls were made to code enforcement.
Okay. All right, thank you, Ryan. All right, so related to that, you had mentioned that there was some traffic issue that you had resolved. What was the traffic issue and how did you resolve it?
It just, as the time was too close and I did not openly communicate, I guess in my head thought people would drive in, drive out this way, and you have to openly communicate. So when I told everybody that when you come in, this is where I need you to park on this side, you enter through here, you exit through there, and we're very lucky to have a median, a middle section where people can merge, that it does allow it to be safer. But that was on me, lack of communication, just to tell people how to enter and exit.
And how did you resolve that?
Communicated with them. Yeah, just told them where they need to park. I didn't want them early. Now, I used to get on them because I would be mad if they were late. So they came early. I mean, obviously the first morning. And I was like, I don't need you here 10 to 15 minutes early. I want you here at this allotted time. So making it very clear with communication about when I expect them to be there, where they're expected to park, how they're expected to enter, and how I would like them to leave.
All right, so the regulation has up to 5 people. And, you know what regulate, 260, 230 says that you can have up to 5 people for dance instructions, crafts, music lessons, etc. So what is it that you're hoping for? How big are you hoping that you can build this thing?
It's not about how big. To be honest with you, I've had big classes. I've had classes up to 65 to 107 people, and I'm not there anymore. If I had the opportunity to keep it, close it off, lock it off at 12, that would be heavenly. That's what we have right now. And I have what's called hybrid, so that if they can't make it every day, they have to reach out and communicate to me. They cannot just show up to a session. They have their own session times. So it's not like a group fitness where you have 6 classes a day, and when you're off work or when you feel like it, you can go work out. That's not how we operate. They have their own allotted time. If they miss it, they can't come to another one. So I really can prevent an overflow, a backup, or any issues that we would have having too many people. Now, I will tell you, I think I've had, 4 classes with 12 in them. The rest are anywhere between 5 and 9 most of the time.
Okay, so you've had 4 classes with 12 in them.
Where they actually all showed up. It's hard to get people to show up sometimes.
So at a given point, you had upwards of 48 people?
No.
You're not at this facility, at your prior facility.
Right, sir. At my commercial business, I don't want to build this. What I'm saying is, like, 10 to 12 is perfect.
At any given time, 10 to 12 would be ideal for you.
Perfect. Yes. And the reason I say that is, I guess if I came into it with a different mindset, knowing what it would be, but leaving and letting go of my business, of my commercial business, and wanting to work with these women that I've had such a connection with, I couldn't outprice them. So when you come from a bigger business where you're working with 300 to 400 people as members, the price is around 100, you have a price range. If I was limited to 5 people, a lot of these women and men couldn't afford it. A lot of these men and women wouldn't be able to come. So that's why I'm asking. It's not about growing the business. It's about the impact that I have, the freedom that I have with my kiddos, and to be honest, to create a future that they too believe that they can do anything they want.
What about employees?
I have none. I haven't.
Intentions of any?
No. I ran a business. I don't want employees. This is just me, just doing what I love with people I love.
Signage and lighting, it was given in testimony, and I believe in the application that there is no signage and no lighting on the property.
There is lighting on the barn but there's no signage. I don't want signage. To be honest, I had a panic attack thinking that my business was at my house. It's actually heaven, but I want it very discreet. That's why we have the privacy fence up too.
Talked about noise canceling stuff and foam and everything that you've done to the barn. Talk to me about music and noise.
Well, at my last facility, my ears used to ring all day long, and I wore a mic. and I can't hear great, and I no longer wear a mic. It's very personal. The music you can have a conversation in. I can talk across to Ryan, or I could go in the back to somebody. It's not loud. We have the bass turned down. To be honest, when I'm in there at 4 a.m. till 11, I don't need loud music, and it's not that setting. So if you were working with a personal trainer, your music is in the background. It's not the forefront. In a group fitness facility like Cycle Bar or whatever, you really need that music to pump up the community. So, no, the music won't be an issue. And if that's why I went over to Jason several times and said, "Do you hear anything? Because if so, please let me know." But
All right, so you say music's not going to be an issue, but the intent or the ideal would be that you do have music at the classes, and the classes start at 5 a.m.
you can't hear. So with the soundproofing, I also thought it would be great for heating and cooling. It's great for keeping it warm, but not cool. But what is great, you can't hear anything. Like the second, I mean, he was there, like you can't hear the music at all. It's on a low key, but when you close the door, there's nothing. And when you open the door, you can't hear it from the outside. And I guess that's all the soundproofing that I paid for.
All right, other questions?
You did say that you had gotten some letters from your neighbors, and they had attested to they don't hear anything.
Correct, yes.
Several of those, or just that one?
He's literally like from him to me, neighbor. So that's the
Who are we talking about?
Jason.
Presented from him.
Facing the house, which one is Jason?
Facing the house.
Off of 22, left.
Yes.
The thing is, my pet peeve is the parking issue. And so you're going to work on getting the parking area enlarged where you can have people there. Even if you have your max for any event that you may have, you will have the proper amount of parking space and spacing between each car so people can move.
Absolutely. And if you have any suggestions, I'd love to take them to make it the most efficient way possible. I mean, that's not my specialty, but yes, I absolutely plan on doing that and would love any suggestions on how best to do the parking lot if that's something that you're able to offer.
Hours that are noted are 5 a.m. at the earliest and 9:45 a.m. at the latest. Do you intend to stick with that schedule?
I have my kids every other weekend, and Friday mornings are the only mornings that I get to take my kids to school. So I don't work weekends and I don't work evenings because Wednesdays and Thursdays are the evenings. So I actually just train Monday through Thursday so that I can have that quality time with my kids, and I don't regret it if they're home and I'm working.
All right, other questions for Ashley? Thank you. Okay, is there anybody here wishing to speak in favor of the application? We all are. You're all in favor. Thank you.
Ashley said it well enough for all of us. We all go.
I just come forward. You can speak for everybody. If you want to.
Another thing, so I don't want to bore you all.
Raise your right hand, get sworn in, state your name and address.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
And address.
Andrea Hauser, 6315 West Highway 42, Goshen.
Okay.
We all are members of Ashley's group, and we just support her and we support what she does. Our lives have been better for being a part of what she has. She's done everything to make the place comfortable, not just to the people that come there, but to the people that live there near her. When you pull in the morning and the music's on, you can't hear it. It's just it's like having people over for dinner. From 5 a.m. to 9:45. You know how you put people in your your house and your parking areas, and you guys negotiate how you're gonna park before you get there. We didn't have that in the beginning, we have that now. And it's a well-oiled machine, it's right there off of 22, and, you know, we can't say it any better than she has said, the impact that she's had on all of our lives, but we can say that without this place, it would be detrimental to several individuals who have suffered health issues, Barb being one of them. So we're just here to show our support, and then also because I had to be here because I'm next.
Very good, thank you. Questions for Andrea? All right, anybody else wishing to speak in favor of the application? I can get you sworn in. And
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
move the mic a little bit closer to you. I'm sorry, name and address.
3101 Reading Road, Goshen, Kentucky. And my name is Polly Hill.
Polly?
Polly.
Polly, okay. Yes, Polly.
Parking issue.
You can speak into the mic.
To the parking issue, I think a lot of it comes on us for not necessarily listening to her in the beginning. And like we all just kind of, came in and parked wherever because we were excited to get in there. So now she has set boundaries and like really adamantly told us, you have to come in this way, you have to leave that way, you can only park here. And now everybody knows that. And if we don't do it, then we're in jeopardy of not being able to belong there. So I think that everybody has the point now. And it's just taken a while to get through some of the kinks.
Okay, thank you. Okay, questions for Polly? Thank you, Polly. You can take a seat. All right, anybody else wishing to speak in favor? Opposed? Board members, questions for anybody? All right, so Ashley, if you can come forward again. Just before I close the floor, I want to at least express the concerns I have, and then we'll I'll also bring it up in discussion after I close the floor. But I have three concerns. Parking, which is of least concern, but when I saw pictures, I did see 7 cars, and then I saw the 4 cars on the other side of the property. Well, that's 11, and it looked pretty full to me. And if you're asking for 12 people, and I see you smiling and shaking your head, parking's a concern for you as well. So one, parking is a thought, and the general character of parking. I don't want to say junk up the neighborhood, but I don't want it to become a parking lot. And per what somebody that's spoke in favor said, it's just like a dinner engagement. You got a bunch of people and worried about trying to coordinate parking.
It's just, yeah.
It's fine, but we're talking about 6 days a week. So I'm concerned about 5 days a week, 4 days a week. Thank you.
Okay, I mean, it's here or there, right?
So that's one of the concerns I have with the parking is just an abundance of cars looking like a parking lot 4 days out of the week. So that's.
I agree. I grew up on a very neat house, and our lawn, our landscape, how we looked. So the reason it looks junked in right now is because the tree that was removed, they came in and ground up the stump, but the stump hasn't been like all the shavings and the ground. It's huge, right? That all needs to be taken away. That needs to be dug down a foot, and then gravel needs to be put down, and then tar needs to be put down. So right now, why it looks junky is because nobody can park there, even though I had the tree, because it's about a $6,500 to $7,000 project.
Noise, I said I had three points I just want to bring to your attention. Noise is the second thing, and there's been testimony that it's very limited, but just protecting the neighbors.
Absolutely.
Noise is a concern. And thirdly, and the most important, and I know Charles, you're going to absolutely agree, is the safety. Coming and going off of 22 is, and directing people, and I've heard the testimony that it's just communication, and it may be that we need more than just communication, and it could just be as easy as small sign saying enter, exit. Don't know.
It's true.
I'm going to talk about it with the board here in a minute. But those are my three things: is the parking lot, the noise, and the safety. Those are my three concerns.
And I am in complete agreement to those concerns, and that's why I said if you have any ideas about entry and exit or parking, I would be gladly to do those. Okay. Thank you. All
right, before I close the floor, any board member, anybody else? Thank you, Ashley. Okay, I'll close the floor, open it up for general discussion. And you guys heard mine.
Let's, let's deal with those. Those are important. I'm satisfied with the fact that she's aware of the issues, and there's still a part of that issue that needs to be fixed, and she's working on that. And that's the parking lot. I think that's why I said, will there be enough space for people to park, enough spaces between cars, so that it doesn't look like a junky parking lot. That was the other part, which is you brought up, which was a pretty good. I didn't think about it. Was designated way in and a designated way out. 22 is not a place to play around, in case you don't know that. And the parking issue can make you liable as well. So we need to be, you need to be particularly aware of that. And the sound issue, I think that what you have is sufficient. That's me. But the parking issue is not just a issue. I think it's going to be an ongoing issue, one that's going to have to be addressed, looked at every month or every 2 weeks, so that you protect your people that come in, your client, and yourself. That is a great concern because of the area that you're dealing with. There's nothing to play with there.
So, are you considering a motion, Gretchen, or anybody else? And if so, do you want to?
Thing, just the enter and exit, would that can be considered signage that would not be acceptable?
Well, that was my thought. The enter and exit, if there's a sign that says enter here and a sign that says exit there, and we say no signage,
Clients
are we
with
in
that?
contradiction?
And that it starts to look really commercial. You know, this is zoned residential, and the number of cars and the activity, and now you put out signs for enter and exit, that becomes.
Question.
I think it's important. The biggest issue out there is that we've had complaints that they are backing out onto 22. Speed limit there is 45 miles an hour, and that creates a dangerous situation. So they need to be not back out, whatever their parking arrangement is.
I'm sure that, I'm speaking to Ashley. If maybe, in the absence of.
Sorry, I've already closed the floor.
I'm so sorry, yes. Sorry.
I can reopen if you want, but.
Well, let me just say this then in general discussion then. I'm sure there's a contract that's signed at the beginning, maybe that could be just included in the contract since there can't be signs or there shouldn't be signs, or that is an issue possibly with signs. That this could be something that she specifies to her clients in writing just for her own protection. I wouldn't necessarily add it to the conditions of approval, just as a suggestion.
Okay.
To whomever hears it.
Well, all right, so what about, I don't see on the potential conditions of approval, what I don't see is limiting the number of people on site at any
I
given
have
time.
it written in as an addition
All right, and what do you have written in, 12, up to 12?
of up to 12 people and 5 a.m. to 9:45 as 2 additional conditions.
Oh, the time, very good.
So, I think that covers it.
So we're saying she can only operate this between 5 a.m. and 9:45
Yes,
every day or 4 days a week?
yes.
4 days a week.
I have that written in.
So in order for her to change her business plan, she'd have to come back and get reapproved.
That's what I have written.
To make sure you know, her last class begins at 9:45, so I don't know if you want to make that.
Our class? Oh, okay, good point. Right. Shall we say 10:45 then as the stipulation? Is that-
And then state the days, the 4 days.
And I have 4 days on there, yes. Okay. Well, the arrival then will be before 5 a.m. So let's say, 4:30?
4:30 to noon, or
Well, she said 10:45 would be, or leaving though, 11.
To start at 5 a.m. and the last class end at
In
9:45.
between those times.
Somebody stays an extra
Okay.
10 minutes and you put down 10:45, then
Perfectly fine. Okay.
All right, any other discussion? All right, I'm ready to hear a motion.
Motion to approve the application requesting a conditional use permit for a home occupation personal training on the property located at 4802 West Highway 22 in Crestwood. The proposed use will not impair the integrity or character of the zone if there are specific restrictions on location, size, extent, and character of performance. There are also adequate public facilities, including sanitation, water, sewage, drainage, and access to emergency services. Conditional use, potential conditions of approval. The conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing. No alterations of the external appearance shall be made to change the residential character, including signage. No on-street parking shall be allowed at any time. No goods, products, commodities shall be displayed or stored on the premises for the expressed purpose of resale. The applicant shall apply for and obtain any required permits and inspections for work performed on the pole barn. In addition, training will only take place between the hours of 5 a.m. and 9:45 a.m. 4 days per week, and no more than 12 people per personal training session. That is my motion.
Is it 9 a.m. or 9 p.m.?
9 a.m. It's 5 a.m. till 9:45 a.m.
A.m.
No,
A.m.
it's only morning.
All right, we have a motion. Do I have a second?
A second.
Discussion? All in favor signify by saying aye.
Aye.
Those opposed? It's been approved. Board, it's 12 o'clock. We've got three more cases. Do we just keep plugging forward?
Yes, we do.
Everybody good? We've got peanut butter crackers if I need to pass them out.
water or anything?
I'm fine.
Good. Thank you. All right, Gretchen, read the next one, please.
Docket OC 22-040, an application has been filed requesting a conditional use permit for a detached accessory dwelling unit with a location variance and maximum square footage variance for an existing structure located at 6315 West Highway 42, Goshen.
What are you doing, Ryan?
Once again, Ryan Fisher with Oldham County Planning and Development, Senior Planner. So this one today, we are for a conditional use permit with a location and a maximum square footage variance. An application has been filed requesting a conditional use permit for a detached accessory dwelling unit with location and a maximum square footage variance for an existing structure located at 6315 West Highway 42. So here is your zoning. It is in an AG1 agricultural zoned area and 39.483 acres. No previous site history. And the case history is the adjoining property owners were notified on October 31st, and the notice appeared in Oldham Era on November 10th. Here is the parcel of land in question on West Highway 42. Here, let's do this for you. The zoning map, where mostly AG1, we do have a little bit of CO1 in there. And the current structures. This obviously does not show the existing pole barn. You'll be able to see that here in a second on some photos. So the applicant is requesting a conditional use permit for a detached accessory dwelling unit with a location and a maximum square footage variance for the existing structure on the 39.483 acres of land. On June 13th, 2022, a building permit was issued to the applicant for a 5,568 square foot slab-on-grade pole barn to include 768 square feet of finished space. So it was a one bedroom, one bathroom. So they're kind of doing this a little backwards. So they built a barn, going to have living space in it. Now they're building a home. So we need to consider the pole barn an accessory dwelling unit. So just kind of get around that.
Wait, try that one more time.
So they built a pole barn with living space. Some people refer to those as barn dominiums now. That's the current up term. Now they're building a primary house. So they have to then now call that pole barn their accessory dwelling unit. So it's going to be located in front of what they're proposing to build as a primary home. So that's where we're getting at. You'll see in a second. It'll all come together. If not, you can ask me questions again.
That pole barn with the living space was permitted as a single family. So that made, they didn't come for a detached accessory dwelling unit because that was the only residential.
What was the primary residence?
The primary residence at the time.
I thought we were building a pole barn. I'm looking at plans for a house.
So the pole barn's already there. Like I said, I think it'll come together at the end. So the applicant is proposing to build a single-story, 3,030 square foot, one bedroom, 2.5 bathroom, single-family residence with a 4-vehicle attached garage. Section 250-040E number 1 states that detached accessory dwelling units may only be allowed after the approval of a conditional use permit. Section 250-040E number 8 states that detached accessory dwelling units shall not be located in front of the primary structure. So the applicant is requesting that location variance to have the existing already built pole barn, which will be the accessory dwelling unit, placed in front of what they're proposing to build as their new single-family residence. Section 250-040E, number 5, states that detached accessory dwelling units shall not exceed 25% of the primary structure's square footage. The proposed primary home is 3,030 square feet, which would allow a maximum of 757 square feet of ADU space. The applicant has an existing, in the pole barn, living space area, finished space of 768 square feet, which requires the applicant request the maximum square footage variance of 11 feet. Okay. Now you'll see on the plans in a second, the basement, it appears through the plans to be finished. They'll have to change those up. Currently though, they're not going to finish that basement. So if the applicant intends to finish that basement, it'll kind of nullify but right now they have to ask for 11 square feet of the maximum square footage variance. The applicant meets the remaining regulations in the Oldham County zoning ordinance, section 250-040. So here is the property. So you see where the current pole barn is, and then where they plan to put the house. So up at the top, you'll see they've kind of labeled distances on where they're from. There's approximately 467 feet between where they're going to build the house and where the current pole barn sits, roundabout. And here's just a zoomed in for you, a version for you to see where the current pole barn is and where the house will be. House will be. So here's some photos that were taken. To the left, I put a red circle around that existing pole barn. And then this area back in here is about where they're going to put the house. And you'll see some more photos of that. So this is from the roadway. And here are just a couple pictures looking west down 42. And then west on 42. So here is the area. It's probably hard to see for you, but they had staked this out when Adam went out and took these photos for me. So you can kind of see the area of where the house is going to be. I'm noting them with my cursor in case you can't see them where the stakes are located at. Looking at that existing tree line, you can see a little bit of the stakes and the line sort of matches the color of the grass, but trying to help you out as much as I can there. You can see the string. And then just here are some elevation images of what the single family residence plans to look like. And then the first floor plan. and then the basement portion. And like I said, I had to call the applicant because it appeared this was finished, and then when she told me it wasn't going to be finished, like, well, we'll have to do the maximum square footage variance of 11 feet. So when I did talk to them, their plan is to eventually finish that, but currently no. So the conditional use permit applicant is requesting a conditional use permit to allow the construction of really their primary house, but in order to have the pole barn that's already there as the accessory dwelling unit. So that may be confusing, but. And then the variance, applicant is requesting a location variance to allow the existing detached accessory dwelling unit to be in front of the newly proposed primary structure. And then the maximum square footage variance, the third part, applicant is requesting a maximum square footage variance to allow the accessory dwelling unit to exceed 25% of the primary structure's square footage. And as we've already talked about, the requested variance is 11 square feet. So the potential conditions for all three of them, conditional use permit, location variance, and maximum square footage variance shall only apply to the application considered here at the November 17th, 2022 Oldham County Board of Adjustments public hearing. And with that, I'm sure you'll have some questions. Me and Mr. Urban will entertain them for you.
Thank you, Ryan. Questions for Ryan?
The idea is that we're reclassifying the original single-family dwelling as an ADU. That is a situation in and of itself before moving forward, correct?
According to our regulations, because the size of this parcel being 39 acres, and zoned agricultural, they really didn't have to come in for another unit because you can have family members live in structures on a farm. But because things change all the time, and because we always try to project into the future and maybe issues or conditions, not on their part, but on mortgages or whatever, we highly recommend it, and the applicant agreed to come in before you and do this procedure where they get a conditional use permit for the accessory dwelling unit that's already there. That's why it's backwards, but it's all okay.
We have no plan of the actual existing barn. That's not here.
Well, there is in the building permit for that.
The plan of the new house being built, which will be the primary residence. So then what we're approving is the additional structure, which will have a living space.
The primary structure of the main house that hasn't been built yet, and again, like
Secondary structure will have a living space.
that's the one that already has it. Yes.
So what we're working on is, well, number one, it's going in front of the primary, what will be the primary living space, and it's too big. Exactly.
Okay. Right? But it's just backwards, but again, it's make sure that we have the conditional use permit for that accessory dwelling unit.
We have no issue with, it's like a, pardon the expression, mother-in-law suite in the front of another house. You can have someone living in that facility. We've approved those before.
You have approved those before.
Yes, okay.
Conditions here are equivalent to that and choose to approve it. That's what we're asking you to consider.
Okay, thank you. Questions?
No.
Are you sure?
What to ask at this point?
Okay, if we can have the applicant come forward, please. And you've already been sworn in. So just state your name and address again, please.
6315 West Highway 42, Goshen.
Okay. And you could clarify anything or justify the project.
The reason it's backwards was LG&E. We had to have a primary residence for LG&E to put a pole in. So when Brian Clore, who is our neighbor and also sold us the property, that's the way we had to apply for it the way we did and why we're here today. So we always knew what our plan was. It was just we had to figure out a way for Oldham County and LG&E to speak the same language, which was kind of like herding cats, but we did it, and here we are.
Can you tell me the the intent of the ADU, of the accessory dwelling unit?
Owns a landscaping business and it's storage for farm equipment. And we are a farm, so we have intent of planting trees and things like that to.
Okay, okay, all right. So once the primary residence is complete and you move into the primary residence, the intent of the existing accessory dwelling unit, or whatever it's considered right now, but what will be the accessory dwelling unit, the intent of that is storage?
The barn part, the dwelling part, for us to comply with LG&E's rules, I have to have somebody living there for 5 years. Our daughter, Harley, works for our company, and she is going to live in that to satisfy their requirements.
Gotcha. And that's the 700 plus square foot area?
Apartment.
Yeah, okay, okay. Okay, thank you. Any questions for Andrea? All right. Is there anybody here wishing to speak in favor? Opposed? Anything else to add? Board, questions for anybody? Okay, I'm going to close the floor and open it up for discussion. Be cut and dry.
It's going to be 3 motions, correct?
It's 3 motions, yeah. Then let's do the,
The conditional use.
I guess the CUP first, and then and then location and size.
Okay,
Ready to take a motion whenever somebody's ready.
all right. Motion to approve the conditional use permit for a detached accessory dwelling unit with dwelling unit at 6315 West Highway 42, Goshen. The proposed use is compatible with the surrounding land uses and general character of the area. The proposed use will not impair the integrity and character of the zone if there are specific restrictions on location, size, extent, and character of performance. Potential conditions of approval: the conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing. That's motion 1.
Do I have a second?
Second.
Discussion? All in favor signify by saying aye. Aye. Those opposed? Okay, very good. Go on to the next one.
Motion to approve 11 square foot variance for the ADU that is being reclassified, the building being reclassified as an ADU, which is already in existence at 6315 West Highway 42, Goshen. Conditions of, I'm sorry. Is compatible with the surrounding land uses and general character of the area, and the conditions of approval are that the conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing.
All right, very good. Do I have a second for that? Discussion? All in favor signify by saying aye. Aye. Those opposed? And the last one, please. Location.
Motion to approve a location variance for an existing structure located at 6315 West Highway 42 in Goshen. To the location variance will not alter the essential character of the general vicinity, and it is compatible with surrounding land uses and the general character of the area. Potential conditions for approval: the conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing. And that is all.
There you go. Do I have a second?
I'll second.
Discussion? All in favor signify by saying aye. Aye. Did everybody, any opposed? Did everybody voice that?
Yes.
It's been approved. Okay, Gretchen, we move on to the next one.
At OC 22-041, an application has been filed requesting a front, side, and rear yard setback variance for a proposed use barrel storage in an existing structure located at 2600 East Highway 146 LaGrange.
Thank you.
Once again, Ryan Fisher, Oldham County Planning and Development Senior Planner. So this is for a front, side, and rear yard setback variance at 2600 East Highway 146. So the application has been filed requesting that for proposed use of barrel storage in an existing structure located at this property, 2600 East Highway 146. It is zoned I-1. I know your staff report says I-2. Is actually, they've kind of own the whole property, and it actually splits right there. So that's one thing that I've changed from your staff report. So it's an I-1 industrial district. The regulations still comply to either, whether it's I-1 or I-2. So just want that to be clear. Land use is currently commercial, and it sits on 20.13 acres. No previous site history. Those adjoining property owner notices were mailed out on November 1st, and it appeared in the Oldham Era on the 10th of November. So here is the property in question.
Is it, what's Northland or?
Yes, this is on that property. So here's where you can see that zoning map. So where they own this entire piece of land going all the way down through here, but it actually changes zoning area. So that's where that error was made. So the applicant is requesting a front, side, and rear yard setback variance for a proposed use of barrel storage in that existing structure at 2600 East Highway 146. The existing building is an estimated 53,787 square foot single-story structure with concrete and also has metal siding. The applicant seeks to change the use of the building from existing lumber storage into a barrel warehouse structure. So regulation section 250-320, barrel warehouses, is one we don't normally see. So I did attach that to the back of your staff packet for you to look at. If located in an industrial, either industrial zone 1 or 2, states the following provisions must apply. No owner or operator shall construct or operate a facility with noxious emissions unless it is equipped with and utilizes the best available control technology as regulated by the Kentucky Division of Air Quality and determined at the time of construction permit review. Maximum allowed building height shall be 60 feet. All structures shall have a front, rear, and side yard setback of not less than 250 feet. When a barrel warehouse is adjacent to a residential use, the setback shall be 500 feet along the property line abutting residential use. So really the one that we're looking at here for this is going to be the one highlighted in yellow. Existing structure is currently located closer than 250 feet to the front, rear, and right side property lines. Current building sits 47 feet 6 inches from the front, and you'll notice here in a second that building is angled a little bit off to the property line. So at its closest point, it's 47.6 feet away from the front property line. Not all of the building does. So you'll see that here in a second. 64 feet 3 inches from the right side property line and 12 feet 9 inches from the rear property line. Therefore, they are requesting 3 variances of 202 feet 6 inches on the front, 185 feet 9 inches on the right, and 237 feet 3 inches in the rear. That'll be easier to read here in a second for you. And the applicant's requesting the variances to keep the current building as a reasonable land use as well as provide a more economically viable industrial use. So here is the plans that the applicant provided. So you see how it is angled to the property line. So at its closest point, you'll see the 47.6 square feet, and you'll see this also in the pictures later as well. Here are just some plans of the structure. I know that probably doesn't make a whole lot of sense, but the applicant may be able to provide you a little bit more information about this. And then just some pictures looking down 146. Back the other way. In the rear, you see the CSX line directly behind the property line here. Some pictures from the building looking at the gate coming in off LaGrange Road. Looking down the front side of the building. Looking down the other side, so you can see where the property line sort of changes. It's where we're at its closest point now as it is to the front. And then in the rear, again, the topography here, it is a much steeper grade down on this end, but the railroad tracks still, for your reference, are down here on this right side of the photo where my cursor is. And then some views of what goes down that right side property line in between their two buildings. So in summary, the applicant is requesting a front, right side, and rear yard setback variance for a proposed use of barrel storage in an existing structure located at 2600 East Highway 146. So that front yard setback variance, required front yard being 250 feet for the barrel warehouse, barrel storage, requesting it to be 47 feet 6 inches. So that variance requested of 202 feet 6 inches. Your side yard setback variance, once again, same required side yard. So the variance requested is 185 feet 9 inches. And then the rear yard, same required rear yard of 250 feet. And so you're looking at a variance requested of 237 feet 3 inches. Potential conditions of approval, the variance shall only apply to the plan considered here today at the November 17th, 2022 Oldham County Board of Adjustments public hearing. And the owner or operator of the facility must utilize the best available control technology for any noxious emissions as regulated by the Division of Air Quality and determined at the time of construction permit review. That is all I have. I know the applicant has a presentation as well, which I'll bring up for them, and I'll entertain any questions you may have.
Brian, I've got a question regarding the setback. Again, tell me so if it's located in I-1, it has to be 250 feet for all the setbacks, but that's different than if it's in a different zoning regulation, correct?
Go up above, you'll see the other zoning area that it can be in is an AG2.
Yeah.
And that has the setbacks of 500 feet. So this is really the only three zoning areas we have where you can have barrel warehouse storage. So it just goes in to show, I-1 or I-2, you've got the 250 feet setbacks. But if you try to put one in an AG2, you've got to comply with the 500 feet setbacks.
Okay.
Or if you're abutting a residential area in I-1 or I-2, you have to be 500, but this doesn't apply in this case.
This doesn't abut residential.
It does way on the other side of the property, on the other side of the railroad tracks that they own, but far, far away.
Okay. Any questions for Ryan? All right, if I can have the applicant come forward. Good afternoon.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth. Thank you.
Are you representing?
Yes, my name is Christian Miller. I'm from Bardenwerper, Talbot, and Roberts. Our address is 1000 North Hurstbourne Parkway, Louisville, Kentucky 40223. And I represent the applicants in this case. As you can see, what you have before you is basically it's an adaptive reuse of an existing warehouse facility. And we're changing that, or proposing to change that into a palletized barrel warehouse facility. I say that's important because we're not talking about building a rick house here. We're not talking about building a 60-foot structure. It's just adaptively reusing the structure that's there. So it'll be a small, and I think you'll see a safe facility that kind of fits within this industrialized streetscape here. There we go. All right. And I think you saw some of these before. This is the subject location. There it is zoomed in. It's that current existing facility there, the building, the structure next to it will be demolished for, again, to increase the safety by putting a containment pond in there. This is the current zoning, which is largely industrial in the adjacent parcels. You'll see I-2, I-1. You see a number of current industrial uses in the area. This is the street view facing north. You can see that large warehouse facility as it currently sits. We went farther up, you can see past that, there's vacant property, again owned by the applicant. Facing south, you'll see again the streetscape here where we have these long, not terribly tall warehouse facilities down through here. And then across the street, there's kind of a berm and a little bit of vegetation before you can see the industrial area across from it. And this is the current use. There are these open doors, and inside is stored lumber, hardwood flooring that's brought in and out, and you can see that there's a lot of airway space, and it is just a concrete and steel facility. And the proposed adaptive reuse is to take that facility and add walls to make a barrel storage facility. And you can kind of see there, I'll show you a little bit more toward the end of this, but you can kind of see that there's these pallets where you put the barrels on the pallets and then stack the pallets on top of each other. And it ends up being about 6 pallets high. And I'll show you a little bit more about that later. And this is the design. You can see here we've got that open bay is still there, and then totally enclosed are these 4 separate bays, these 4 separate warehouse facilities. They're separated by fire-rated walls. They're entirely enclosed. They have fire-rated doors. And again, it's all made out of non-combustible material, concrete and steel, which I think is especially important when we're talking about storage of barrels of whiskey, right? Because we're mostly concerned with safety at this point. You know, we don't want any kind of fires that could cause any kind of issues. So think of these really more as like 4 separate facilities after the fire-rated walls have gone up and they've had this separation put together. Again, these are the regulations that are in effect here because we are in an industrial district. I believe when we were just talking about the agricultural district, the other area where you can put a barrel warehouse facility, I believe those also require that you're running a distillery. Is that right? And that's not what we're doing here. This is just a barrel warehouse facility. And yeah, our primary issues here today are the setbacks, those front, rear, and side yard setbacks. And I believe, yeah, here's our design, kind of showing you the yellow building is the current building, the one we propose to adaptively reuse. You'll see just to the northeast of that is where that other current existing building is that will be removed, and a containment pond will be put in. And you kind of see, oops, I went the wrong way. You can kind of see from the setback lines, we actually used the 500-foot rear yard setback line, but the 250-foot setback line puts us in the same position. As you can see, that it's very challenging, especially at this pinch point of this long parcel of industrial property, to really comply with those setbacks, which are very large setbacks. And you know, presumably these setbacks are there for safety, and also for this naturally occurring microflora. I'm sure you all have heard a lot about, I mean, we live in Kentucky, right? I mean, In Kentucky, we all know about barrel warehouses. We've seen these huge rick houses with facilities with hundreds of thousands of barrels. And they talk about this naturally occurring microflora. Well, that's just the ethanol, and I'm no expert here. I have a team of experts with me who can answer your questions about a lot of these issues, but this is what I've understood from them, that it's the aging of bourbon or any distilled spirits or bakeries or gas stations that have ethanol as an additive. All of those can trigger additional growth of a naturally occurring microflora called Bauduina compniacensis. And to our understanding, there are no known health concerns with this naturally occurring microflora. And to address that, the regulations require this BACT, this best available control technology, which while the team has been reviewing the regulations and the standards for this, they've been unable to find any facilities in the state that use a BACT system for barrel storage. In fact, they contacted the EPA, who also did not understand a requirement of a BACT system for barrel storage. They've noted some problems, that it's extremely high cost. And, in our world of concerning ourselves with energy efficiencies, that can cause some issues with that too. And we only point this out because, this additional requirement by Oldham County is a very strong requirement that has huge impacts on these facilities. So I'll just point out there's a couple of possible treatments that I've talked to with our team here. One is called an incinerator with carbon scrubbing, and that requires a steam boiler. It's very energy intensive. The other one is this chilled water way of encapsulating the ethanol. Uses less energy. It's not zero energy use, but it is less energy. And then there's also a residual ethanol that you're able to process and use, not as a distilled spirit, but for other ethanol uses. And then again, just for this one warehouse, the team is estimating almost $1 million to install a BACT in this facility. So this is not an operation that anyone's taken lightly. This is not a system that anyone's taken lightly. It's a serious system. And there's also annual operating and maintenance costs that go along with this. And so with that, I just kind of want to address, what are we talking about here in terms of let's say worst case scenario. We had no BACT. We had no way of containing any of this ethanol and stopping any additional ethanol being put into the ecosystem. Well, this was our best estimate at about 1,000-foot radius from the property. And you can see a large portion of what is affected here is my client's property, because they run that entire length of that kind of pinch point property there, and it goes on up to the northeast and down to the southwest. And then there's some vacant land to the north there, and an industrial use, and then more industrially zoned properties to the southeast. And so I give you that as kind of a radius, but then another important thing, as I've learned, is the prevailing winds. Right, so we look at the prevailing winds here, and again, I've got a team of experts here who can answer your questions on these. But just to give you a synopsis here, prevailing winds in this area, I've been told, are from southwest to northeast. So if you look at those prevailing winds, and then you look at the elevation that this warehouse is on, kind of two factors that would go together, right? You saw the earlier pictures that there's a railway behind this. That railway is actually down in elevation. So the warehouse sits up, looks like roughly 15 feet higher than the railroad. So those prevailing winds should be hitting that warehouse, is my understanding. And so now we talk about, where would anything that's emitted from this factory as it sits, or with any future use, where would that fall zone be based on those prevailing winds? Well, if you follow the southwest to northeast, you see it travels largely along the property that's owned by my client, and goes to the north, it travels largely into that vacant industrial area. And here you can kind of see that red outline shows the entire property that's owned by my clients, and how this fall zone is almost exclusively on their other portions, their other tracts of this parcel. Another concern when we talk about having a barrel warehouse facility is containment. What if the worst happens? I think you've probably all seen in the news, a lightning strike hit a rick house and it caught fire, or something like that. So what you deal with is containment. And so what we've proposed here is a containment pond, essentially, that's just to the northeast of this parcel. You can see it's 2,610 cubic yards proposed, so that would be demolishing that structure that's there, putting in this pond, and then going through measures, including swales and a berm, so that any fire water or whiskey spill would be routed from the building through those swales, through that berm, to protect any adjacent properties. It's designed based on two requirements, or two standards and requirements: the Kentucky Building Code, which has its own requirements, and then the Distilled Spirits Council of the U.S. So these are national standards, and our design team has used both of those to design this spill containment pond. And remember, I talked about how this is really 4 warehouses. So it's sized, and again, this is based on standards and requirements, sized to contain the total quantity of whiskey in one of those buildings and 20 minutes of water from the building sprinklers. So we're talking about a very large pond, and it's also sized for the 100-year flood and the total quantity of barrels in the largest of the 4 warehouses, which is, again, is the industry standard. And remember, the others are actually separated by fire-resistant walls and non-combustible construction materials. So what you anticipate there is not that you would be dealing with any of the barrels or any of the water or anything from those other 3 warehouses in the event of a catastrophe. And I think this is important too. So we talked about safety. We talked about, the reason for this variance is this pinch point. We talked about where the fall zone would be. I think it's important to remember the scale of this facility, because this is a very small facility. It's an adaptive reuse of a current facility. The maximum building height per the regulations would be 60 feet. Well, palletized warehouses, because of their unique structure, are capped at 27 feet total. So that's less than half of what would even be permitted by Oldham County standards. And this proposed facility in total would have somewhere between 25,920 and 32,364 barrels. And that's between the 4 warehouses. So roughly 6,000 to 7,000 or 6,000 to 8,000 barrels per warehouse. And those are, again, based on this palletized structure. So you have each one of these bourbon barrels, which is about 3 feet tall. So you stack 2, you're roughly my height. You stack 6, you got three of me standing on top of each other. And that gets you about 20 feet tall. This also will actually improve the industrial traffic through here, because this is a very low truck traffic generator. These barrels are intended to sit for 4 years. So once they're brought in, that's where they are. And then the lumberyard does plan to continue to operate on other parts of this property. You saw there's a very long parcel here, and there are other buildings in which they do plan on continuing to operate. And so we would ask that you would grant the front, the side, and the rear variances here. Because, I mean, this picture, I think, kind of tells it all, because this adaptive reuse will maintain the streetscape, maintain the scale, and also increase the economic utility for this area by providing this very efficient palletized barrel warehouse that's also has a lot of measures in place to make it extremely safe as well. Like I said, I have members from our team here if you would like to ask questions of people with a lot more education and engineering and whatnot than I have, which is really zero. I would ask that you would thoughtfully consider, and again, I really appreciate everything y'all have done here today. I don't want to belabor this point, but we're here after 12:45, and you guys have worked really hard, and I know you do this as a public service, and really appreciate all that you do for us. So with that, if you have any questions.
Questions?
Question? I have two concerns. One is, even though you say that that big trucks will be coming through here for a certain period of time, that's not always the case with these storage places. Because you get the burros, and I don't think trucks bringing burros in and out will stop. So I'm concerned about the big trucks moving through the area. The other thing, my other concern is the smell. A lot of these people, they live around all through those areas. They used to smelling nice fresh air, and we don't want, and then you're going to bring in these places in, and I'm sure there's going to be some odor from it. I haven't been around one yet that I haven't been able to smell the liquor in. And I was raised in Bardstown, so I know what they are and what they do. And my people were close to the place that burned down, so I'm pretty much aware of what goes on with it. But so what about the smell? What can you do about it? If that's even going to be an issue? But I smelled it when I go around those places, so if I live around there every day, that's going to be an issue for those people.
And let me, I'll get one of the members of my team who's a lot more advanced in air quality to talk about this. I will.
Yeah, we can do that. If we can go ahead and swear everybody in at once, and that way when you come forward, we don't have to. Dan.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Okay, thank you. And if you want to state your name and address.
Quirk, 2806 Meadow Drive, Louisville.
Okay.
Dana Zausch, 7102 Covered Cove Way, Prospect, Kentucky.
David Underwood, 876 Fetter Avenue, Louisville.
Architect, project manager, architect, and mechanical engineer.
Fantastic, thank you.
Before we get started, I have a question before we continue with all this to know how far we need to get into this. Are we approving a barrel warehouse or just the variance in setback?
Yeah, thank you. Gentlemen, if you all can take a seat, because I think we're going to
need to understand, because I'm concerned that we do not have the expertise to approve a barrel warehouse and what's ancillary to a barrel warehouse, whether it's how far the mold goes, the fire risk, the spillage, and the possible impact on the road, or the railroad being adjacent to it. Are there restrictions on a barrel warehouse that we are not addressing that they've already jumped through the hoop or will have to jump through the hoop? Are we only looking at setback? Because I don't want to get into a whole bunch of things if we have no impact on that.
Makes sense.
Because just as Charles said, I've lived in that area, and I know the metal grinding facility, you can hear that from Dawkins Ridge Road.
Understood.
And if the prevailing wind is such, you put a barrel house right by that facility, you're going to smell that barrel house down there, I bet you.
Answer your question. The application before you is for front, side, and rear yard setback variances only. Barrel warehouses in the I-2 zoning classification are permitted uses. If they met all the setbacks, they wouldn't be in front of you. It would be a permitted use and they wouldn't have to do anything. So the question at hand is, are these setbacks variances, is the request acceptable? I think you have to understand a few things like prevailing winds and especially, and I'm going to talk briefly if you don't mind about this BACT from what I know of it before you can consider this. Prevailing winds are important. Winds change all the time, but what is the general direction of the wind? And they've showed you exhibits as to what they believe are not only the prevailing winds, but we'll call it the fall area. And in us creating regulations for distilleries and barrel warehouses in Oldham County, we did a ton of research. We researched other jurisdictions' setbacks. We researched other jurisdictions' requirements. We also were fortunate, I believe, and we'll always say, very fortunate to have one of the premier distillers in the region live in Oldham County and help us with this, and that was Steve Thompson. Steve has passed away. But he educated us as staff, educated the subcommittee of the Planning Commission, the Study Review Committee, and ultimately Fiscal Court when we adopted the regulations. BACT, the best available control technology, is in the regulations. It's in the regulations in distilleries because there are things like scrubbers that would allow for any exhaust that went up through the building or through the distilling process could be collected. And actually, they want to collect those because it's full of vapor and they're going to put it back in their system. There is no best available control technologies, to the best of my knowledge, and you heard testimony about this. They actually did a good job of researching to try to find out what is that. And we put it in the regulations because Steve Thompson told us one day there might be. We didn't want to have to go back and revise our regulations to put it in there when all of a sudden it showed up. So we put it in there knowing it says available, keyword available. And if there is no available technology, it is not part of what they are required to put in because there is no technology for barrel warehouses only. So the real consideration here, in my opinion, is, are there any impacts on adjoining property owners regarding not the barrel warehouse, because again, it's a permitted use, on not having adequate setbacks. And again, I'm going to keep praising Steve Thompson because he worked with us for hours on end describing, and I think the testimony I heard falls completely in line with what we learned from Steve, is that kind of fall zone is about 1,000 feet, a quarter mile roughly, in the prevailing wind direction. So I think your charge here today is to consider whether these are reasonable variance requests and they are, have justification. I'm not going to stand here and justify it for them. They've showed you that. But it is important to understand whether or not there is an impact on adjoining properties. So I hope that's enough of an explanation without offering testimony or necessarily support, but my head is full of, I could almost be a distiller just from what I learned from going through this process and visiting distilleries in that process. Is that good?
Well, thank you for that, but I still have a lot of questions that I don't think I'm able to answer or make an opinion on this yet.
Well, Mr. Ford, yourself from is, if it's a candy factory, you're talking about various different, I mean, that's the problem the court has right now, is that they may not, they're gonna judge this based on something other than what it's done.
Yes.
And so that you-
Well, that's a good point. If this was something other than just, a bourbon warehouse, that has its own unique challenges and unique things about a bourbon warehouse versus a candy factory.
when we do these down the road, I mean, we're talking about safety features for a fire truck to get through, and we're talking about things of that nature when we're in another part of the county, but, today
So if this had 250 feet all around of setback, we wouldn't even be here. Permitted use, 250 feet, you're good.
In the I2 zoning
In
classification.
the
that
I2
is
zone,
correct.
which is what it is.
Yep.
So why is that 250 feet? The safety, I mean,
No, again, in spending many hours examining other jurisdictions' regulations in the region especially, Louisville, Shelby County, there were 4 altogether and I forget them, Bullitt County, comparing them, and then being educated regarding the, I'll call it the fall zone, the typical area, if conditions were such that it,
which falls out of 250 feet.
we determined that it was 250 feet in an industrial zone area to be appropriate.
Zone of that mold is much more than 250 feet.
I'll defer because we used experts to tell us what it was. We did. We examined all these regulations and we, again, Steve Thompson, God bless him, spent hours with us.
But I thought it was 1,000. What was just shown was 1,000 feet.
But if you're in agricultural area, it's 500 feet. That makes 1,000. So that's what's in the regulations. We can't argue what's in the regulation. The regulation is 250 feet.
Yeah. But
Period. That's what fiscal court adopted as part of the ordinance.
it's an existing structure. What was the regulation? You got it.
You really come to the microphone because.
Okay, well, you got an existing structure that's been approved based upon whatever setbacks were in existence at the time of the building permit. So what has changed because of the nature of the...
It's a different use. It was a lumber yard, not a distillery or a barrel warehouse, rather.
Being stored, the zoning across the street.
They had an exhibit, I believe it's I2. Is that correct? It's somewhere
It's
in
been
here,
looked
but-
at as a residential development at certain points, but that would have to be changed in order for that to happen.
And then across the railroad tracks is I-1, industrial. Now, that's not the use in that blue area. The land use is actually residential. Those are large lot residential developments, residential properties that I believe all of them have a waiver from the Planning Commission to allow a house to be built in a residential zone.
And that's the ones off Miller that are actually behind. Okay.
History, the reason that this land is zoned industrial, and I can only guess this, that when zoning first came in the county, it was along a railroad track, and everybody said, let's make it industrial. We anticipate that this area will use the railroad, and having industrially zoned land there is what was originally placed on all these properties. I think the original use of Northland actually used the rail line. There used to be a spur that went across to the other I-2 zone property when it was a wire and magnet company. Now, again, now we place new regulations that really, to Tate's question, the lumber yard didn't require setbacks any greater than what they are, and that was there, I believe, even before zoning came in the county. I remember the owner of the lumber yard used to be on the planning commission.
We're trying to, let's just say today, put in a lumber yard there, what would the zoning setbacks be? It wouldn't be 250 feet, correct?
There's different setbacks for
250 feet is specific to a barrel storage facility. And you looked into it a lot. Can you give us some insight as to why such a large setback for that specific use?
I think I already did, but I'll explain it again. In doing all the research of
The fallout, the zone, I understand that, that's true. Okay, I got that.
had even greater in industrial. Some of the area regulations had even greater setbacks, some had less, quite honestly.
In Kentucky.
Average and said in the industrial, this is what it would be, what would be appropriate. There's a distillery, and again, barrel warehouse associated with that on Old LaGrange Road, and it's an existing building, and it was done before these regulations were put in place, and they're right next to other properties.
Yes.
You know, we again took, and in some of the regulations, and I'm going from memory, the setback was even less than what we proposed. Just kind of took the average, and we did the research, and we had many a classroom experience down in my office in the conference room to talk about what regulations. We went through the study review committee, probably about 3 or 4 meetings of the study review committee, and then ultimately the planning commission, fiscal court, and all the legislative bodies that are part of the joint planning commission approved these regulations. That again, like any other variance request, assumes all the best conditions, flat, square, rectangular, and you can meet all these.
So what other bodies or approval process has to happen to approve barrel storage facilities? So if we approve setbacks, what else happens?
Yeah. You've got the decision. Mm-hmm. Again, it's a permitted use. You're not really approving I mean, essentially, if you deny it, you're denying barrel warehouse storage here. But you're not considering whether this should be permitted, you're considering whether the setbacks are appropriate, the setback variance requests are appropriate.
And, you know, we had the very first case you had today was a perfect example of and we're not the same issue, but Riverside Drive, I mean, we have had many, many cases where we have to change the setback and sideline and everything else because of the nature of the property.
Yeah. What he's referring to is like on Riverside Drive where you have lots that were created long before zoning came into place, and they don't meet the current standards, and people want to do something on them. You've got to ask for variances. Old city lots in the city of LaGrange are much like that. They're smaller than the regulations, and that's why KRS 100 allows variances to be considered by the Board of Adjustments.
I'm just trying to get the board to think in terms of why we're here today on this particular. Force yourself from actually what the permitted use is already approved.
I mean, and in some respects, I understand that people may smell. You got to divorce yourself from your own opinion about whether you're going to smell it or not.
To that point, I just need to caution the board, make sure that we don't make testimony. We hear testimony, we hear evidence, and
we're here now, and that really shouldn't be coming into the record, to tell you the truth.
Clear that from your head, obviously. If you experience something, it's always in there. But you know, again, the test of granting any variance is, we always put this in your potential motions. Will it adversely affect the public health, safety, welfare? Will it alter the essential character? Will it be a hazard or nuisance? That's the test.
But what my point is we're not here to judge those things. And what I'm hearing about, what concerns me, I'll just tell you what I'm concerned about. He's referring to that as 4 warehouses. I see it as one building, right? He's calling it 4 warehouses to circumvent some of these concerns. If it starts on fire, if it leaks, there's a retention pond, but it's enough for 1 warehouse. This is 4.
One existing building, you're correct, and they are fire rating it for 4 separate cells, let's call them.
My point is, we have no say over that. All we have to say is, will we allow these large changes in the setback? We can't really evaluate whether it's going to cause mold on neighborhood houses a mile and a half away. We can't.
Yes, you can. Will it adversely affect public health, safety, welfare? That's the test. You determine from the evidence.
We're approving is the setback.
That's right.
Again, based on this test and the testimony you're hearing.
My point being, I'm not qualified to make this decision, and I will recuse myself.
That's probably the one thing with past board members.
Sorry.
Past board members that were in the area and had and recused themselves because of some bias or prejudice or because of the location, and if he feels that way, he should recuse himself at this point.
I just did.
My concern, I just heard what you read, which is where I'm at, but I'm not getting the full effect of doing right because I'm only dealing with variances. The meat on the bone for me is the effect it's going to have in those areas you just mentioned, but that's not what I'm dealing with. But I see what you're saying. By dealing with the variances, that voting the way that I think I would like to vote, that would be beneficial, but that's not fair in that case. So I'm a little leery with that one too.
Well, it started out, he had a question about that, and we
Mail.
have expert testimony on it, but we've deviated from all of those issues at this point.
Well, we did, but I think that's because of that's one issue of a whole bunch that I don't think anybody on this board is qualified to. I mean, I agree, Charlie, that.
Can I just suggest before you recuse yourself or abstain from voting, there's other evidence and other questioning. I understand what you're saying, that you don't feel necessarily qualified. All you board members are appointed.
Beyond that, I have family that lives in that airspace.
Yeah, so.
Well, keep talking because I do fall in that.
This is a jury of peers. You're all appointed, you volunteer, that's wonderful, and we apply our best knowledge and skills when making a decision. You hear the evidence, you weigh it, just like if you were called to court to serve on jury duty. You're not qualified to be on jury duty where there's a murder case, but you are called to duty and you weigh the evidence and you determine in your heart of hearts and in your mind whether or not the evidence has convinced you one way or another, and you vote the way you feel. Didn't realize you were talking from the fact that you have a family that live in the area, and that's a different story altogether. Mm. If you all decided to recuse yourself, how would we have a hearing? The other thing is there are people here that are interested in speaking. You need to hear those. And again, it may convince you one way or another.
Right, your job is to listen to the evidence before you. You're not expected to be an expert. You're expected to listen to the evidence that is presented on the application, not your own personal testimony, not your own personal. You've got to listen and make your decision based upon what you hear from the witnesses, and nothing more than that. And hopefully, in every case we have, that's what you've got to do.
So my argument is So I hear the witnesses, I hear testimony, but I'm not qualified to know what I'm not hearing and the questions that I don't know to ask.
You go back to the test. In your heart of hearts and in your mind, will it adversely affect the public health, safety, welfare, change the essential character, be a hazard or nuisance? We do that all the time, and I know this is different science. I get it. This is a different case. You've not ever had one of these before, but I think you're all an excellent board and capable of doing it because you're all intelligent. You all ask good questions. You can always table it if you think there's something else you need to hear about that hasn't been presented. I know you're going to say, well, I don't even know what questions to ask because I don't know what questions I'm supposed to ask. So do your best.
Well, I feel better because you're giving me an area based on those 4 things that you came up to at least focus on with regards to where I'm at with it. And so that gives me a little bit better area to stand on.
Hearing and continue this discussion after that if you need to.
All right, so does Charlie recuse himself or abstain?
Recuse myself.
Okay.
Then you need to.
You need to exit.
Mm-hmm. Okay.
All right. All right, thank you.
Where'd you head?
All right, so the question was, Charles, your question was about smell, and I believe that's where we were.
And just real quickly to address, right, we're here asking for the variance. Variance for the setback itself, as was shown, there are other standards and this is an approved use. And just kind of with that ahead of us, that's why we presented this extra evidence, is to show you that we're not adversely affecting the public health, safety, or welfare. We're certainly not altering the essential character of the general vicinity. Again, when I call it 4 warehouses, it's one building separated by firewalls. And that's, again, that goes to safety, that goes to protecting the public health, safety and welfare, and not creating a hazard or a nuisance to the public, and not unreasonably circumventing the requirements of the zoning. And I only say that because, again, that is the standard, as Mr. Urban said, that we're here to apply to see if you'll grant our request for a variance. So with that, I mean, so we certainly have our design team, our engineer here to talk about your concerns. And I believe you were talking about the truck traffic and the smells, right? Yes.
So the nature of a bourbon warehouse is that they bring the barrels in and there's truck traffic. And they put them in there and they don't really do anything. The only traffic that would occur would be someone coming on a weekly basis to go through to make sure there's no leaks, and then servicing the backed system. But the trucks, and then in 4 years, 4 years minimum, sometimes they go longer than that, the trucks would come back, take out, and bring new. So it would be a cyclical truck use. As far as the smell, yes, there's a smell. I think when you're in Bardstown, there are hundreds of warehouses with way more bourbon than we have in this one. This is a really small use. The other thing that's interesting, those rick houses are very open and they have windows and they ventilate directly. We don't have that option here. The existing building is tilt-up concrete walls. There are no windows. There are some big openings on the front right now that are completely open, which we're building a infill wall, 1 hour wall, right? So we're kind of completing that envelope. Between this building is already divided into these 4 compartments with concrete walls in between them. So there are already 4 compartments. And then the way that the back system is designed right now, there's only one exhaust out of this building. It's not coming out all over the place. And that exhaust is going through a treatment to pull ethanol out of it so that we're reducing the amount of ethanol that's being put in the air, as opposed to just the Bardstown warehouse that's just open air and you get what you get. The warehouses we're building for Woodford Reserve in Midway right now are concrete precast panels, kind of state-of-the-art, state-of-the-fire, fire protection kind of thing. The same approach is taken there. It's a little bigger scale. It's a 90,000 square foot building with that same firewall down the middle that technically makes it 2 buildings by the building code. And they're storing, 90,000 barrels? It's a huge number of barrels compared to this. So this is a small use, but there will be smell. I mean, how much it is, I can't quantify that. I think the other piece that I heard in here was the danger of fires. And bourbon is not explosive, it is flammable. So if a barrel catches fire, the whole warehouse doesn't go up. What happens, the barrels heat up, the staves open, the bourbon leaks out. So it's typically a pretty small amount of bourbon that comes out in that. We are fully sprinkled, will be fully sprinkled to meet both the building code and the DISCA standard, which is a little bit higher than that. But the approach to the 4 compartments is what we do all the time. So these ones for Woodford, our containment pond is for 1 compartment, all the sprinkler water from that for 20 minutes, plus any water that can get into that pond in a 100-year floodplain. That pond is typically empty. It's typically green grass. And then it's ready there, closed off. If there were to be a spill, it would be caught there. If there's not, they open it and let the water go out and down into the creek. So. It's complicated and it's confusing. So we do this a lot. This is all we do, the 3 of us. So we do have experience, but this is an unusual building to be using for bourbon maturation because it does not have the breezes going through it.
And what unique aspects does that create? So you don't have the breezes blowing through it, so what's the result of that?
I don't think anybody knows. The owners are taking a risk that putting barrels in there that you're going to, the bourbon ages by pushing into the staves and coming back out, so kind of a heat cycling. That without that evaporation, is the Angel's share going to change? Is it going to change the taste of the bourbon? There's no study of that. So the Woodford Reserve buildings do not have windows in them. They're mechanically ventilated, but I don't think they've finished a 4-year cycle there yet. I think they're very close. It started? Okay.
So what we have here, this is the 1,000-foot radius for the fallout of the microflora. Is that correct?
No study. There's no scientific data that we can find that help guide us in what to do here. It just doesn't exist. So I think the expert that Jim was referencing had said it may be a quarter of a mile. That maybe.
Mm-hmm.
And again, we're limiting what's coming out of this building to an exhaust. It's not just free flowing. I don't have any science to answer that question. I can just.
All right, no, I think that how you're answering it is perfect. We don't know. Can you tell me the radius that we have here? What are all those buildings around? I think you actually had a slide that pointed out what each one was. And is that residential? I guess that looks south of the picture.
We actually took out, we had a 250 foot, we had a 500 foot radius to
Mhm.
kind of show it. But I mean, at that point, you're talking such a tiny zone. It really didn't show much of anything. This residence down here, don't quote me on this. I believe our best guess was it was 590 feet
Okay.
away from our building.
Okay, and just outside of that is more residents
There's
in there?
down in here, and then I believe there's one over here and one over here. I don't believe this is one.
Okay.
I think it's this one and this one.
All right, so outside of those few residential areas, what do we have that,
They're industrially zoned, again, with waivers for residences. And I'll show you here. I don't say that to say that there's no impact on residences at that point. I just point out that, you know, again, the kind of law that I do, which is largely zoning, you know, one thing we always advise people is when you buy a piece of property, look at the zoning, because
Mhm.
zoning dictates the use. And, you know, don't be shocked. You know, whereas at a hearing the other night, there was in Louisville, they call it M3, here you would call it I3. Somebody wanted to put a concrete plant in there, or a concrete mixing plant, sorry. And the neighbors next to it were like, we had no idea. But it's an M3 zone, and that's entirely permitted within that zone. And that's what we're talking about here. This is a facility that's entirely permitted. Now, granted, we need the variances here for those setbacks, the 250-foot setbacks, which based on, and I wish I'd left it in here now, the 250-foot radius, I don't think we're hitting, certainly don't think we're hitting any residential properties. But as you can see here, I mean, this is what we pulled off of Google, of the industries in the area. And then you're right down there off of Miller Lane. There are some residential uses in that industrialized zone. You know, the other point, we're talking about smells. There is a railroad that runs through here, a railway. I believe all those run off of diesel. And so, I understand you're talking about occasional diesel.
You're missing my point.
And I did not grow up in Bardstown. I actually grew up out here in Oldham County.
Difference between liquor smell and diesel smell. And smells have a different reaction for every individual that smells them.
And this is, you know, this is a very small facility, and it's going to be, you know, it's going to be ventilated internally, mechanized ventilation. I mean, it's a different, it's not 800,000 barrels out at, you know, a Jim Beam facility. We're talking 25 to 30, or roughly 30,000 barrels, you know, depending on how many are in at any point in time. I think a maximum was, back to that, the maximum we were talking about here is 32,364 barrels, you know, so it's, they're just talking about a 90,000 barrel facility. You're talking about 1/3 of that.
I already know that in reference to other places that store liquor, this is a relatively small one. But we're still dealing with the same issues, maybe not on as large a basis as those other ones are, but those same issues still exist here. And they may have some negative effect. That's all I'm saying.
I think that's why we included what Mr. Urban was just talking about, which is this fall zone, this prevailing wind concept, which, you know, we extrapolate that out 1/4 mile, the majority of that fall zone is on our property. You know, I mean, it's an unfortunately situated building for the variance purposes, but almost according to what we project to be the fall zone, almost ideally situated, being down there at that pinch point and allowing those prevailing winds to take it on across their property.
so with this picture here, what are the buildings, or what am I looking at? What's the large building that's just north of the star? What is that? But move the mouse so that you move the hand. Yeah, go up, go up.
That, remember I showed you the berm with the vegetation, and across the street, that's the, I'm blanking on the name of the facility.
The steel plant. Okay. All right. Now where's the propane place?
Up here, I believe.
It's that one.
And then the recycling.
Okay.
And then the RV
Okay.
servicing.
Okay.
Facilities, all of those.
And then south of the star. Actually, I think that's the subject. Where are the warehouses that you're talking about?
Where we propose to
Right
put
there on the
warehouse.
star. Okay.
Down in through here, this is again property owned by my client. And his property continues, actually the company's property continues all the way up through this red zone here.
And then south of all that, you've got a couple of residential scattered throughout here. But that's it. That's all. That's what's south of that is residential.
Span Lane and Henry.
We're pretty close. We're pretty close to the border, I believe, at this point.
So again, I'm trying to stay as focused as I can. If this was 250 feet all the way around, you wouldn't be here. It's a permitted use. You got your 250 feet, you're fine. So my job is to approve or deny the setback variance. That's what I'm considering.
And that's, again, that's why we have included a lot of this information about public health, safety, and welfare, not altering the essential nature, the essential character of the general vicinity, which is largely industrial, which again, this is a permitted use within the industrial area. You know, one of the conditions here is that we're compliant with that BACT, that the best control measures, and you know that goes toward being a hazard or nuisance. It's also of a scale that keeps with that streetscape there in that industrial area. You know, we talk about the traffic that we generated off of this, again, just to kind of show that it's in keeping with its industrial style traffic, right? It's not a lot. It's a little bit of traffic, but it's not a lot. You know, it's an adaptive reuse of this warehouse facility to something that, you know, brings in a larger economy. And yeah, I think that's what most people are looking to do is to always, you know, be improving and getting to that highest and best use. And so that's why we're asking for the setbacks. And yeah,
So what are the things, and I think if you didn't address them, I'll just, you know, ask poignantly, what are the things that need to be considered? You've mentioned, and then I'm talking, I guess, more environmental things. So we've talked, you know, sight and smell. You've talked about the microflora, fire. Uh, what else needs to be considered, or do we need to think about when talking about barrel storage?
again, we're talking about all of these things in terms of the variance that we're requesting. Not, I know it's hard to divorce barrel storage from the variance, but so the way I see it is, if we had 250 feet between us and the property line, all of these problems go away.
They go away.
Magically go away. Like, whether that's reality or not, they magically go away. So if I could wave my magic wand and move our property lines a couple hundred feet, all our problems go away. So what we're really addressing is, do those problems affect within that 250 feet? And I probably should have left that radius in here just to kind of show you what is within that 250 feet. It's a large part of our property. It's not reaching, to the best of our measurements, it's not reaching any of the residential uses to the southeast of us. It touches a little bit into that steel industrial use to the north of us. But you can probably see it better here with these setback lines. You know, this line here is a 500-foot setback line. Because we had originally calculated off of residential standards. So cut that in half. That would be 250 feet off of the rear property line. So you can imagine if you flip that, like, we're not talking about a large distance. Off the front here, that's another 250-foot line. Right here, there's another 250-foot line. And you know, this is, and so that's the request. The request is we're asking you to approve the variance such as to say that the 200 and some odd feet that we need in any given direction, that those do not adversely affect the public health, safety, and welfare, that those don't alter the essential character of the general vicinity, that those setbacks that we're asking for don't cause a hazard or nuisance to the public. And I know you're hearing other testimony too, and you probably still have some additional questions as well, but I think that's what we're going to submit and say that these variance requests for those specific areas for this use, which is permitted, we believe they should be granted because we don't affect those things in those specific areas that we're requesting the variance for.
Board, if you all agree, I would like to go ahead and hear other testimony. Okay.
Appreciate y'all running through lunch and being so patient with us here.
Okay. Is there anybody here wishing to speak in favor of the application? Opposed to the application? Okay. If you would like to come forward. Are you going to also talk? Yeah, come on forward.
No.
Get you both sworn in.
Your hands. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
And name and address. All right, Rick, and you?
1914 Miller Lane.
Okay, let's hear why you're up.
I'm the representative for Miller Lane and Span Lane. I've been doing this since 1998. So also just to bring to your attention that they keep saying this is for permitted use. There was permitted use in LaGrange proper for a doctor who wanted to use office. They had already rented the space, and the city council denied their permit for business to operate the business, even though it was a permitted use. All right, I have a couple of issues with this. Everything on the opposite side of the railroad track from them since the 1970s has been residential farms, and our property is about 21 acres. The property next door to us is 17. Then you skip an 8-acre tract, and then you go to another 17-acre tract. All those go along the railroad track. Then down towards the end of Span Lane, there's another 20-plus acre farm down there. So residential or farming is what I'm really worried about. And I think they're misinformed about what's going on with the railroad track, because every time they replace ties like they're doing right now, they also replace the big heavy tracks, and they get buried along the railroad tracks. So even on our farm, we lose probably 2 to 4 animals a year from lightning strikes. So that's a very, very heavy lightning strike area. I'm just really, really concerned about the odor, and what they're saying fits into the 500 foot is all farmland. It butts up right against. So now I'm worried, and when I came in, I wasn't so concerned about that, but now that I'm listening to their discussion, I'm more concerned about the odor and what could leak out and happen into the ground that we feed our animals off of, because we have grazing animals. We have horses and cows and pigs and chickens and goats, and they're all, feeding off that property.
I grew up in the south end of Louisville, Brown Foreman, the distilleries, the smell down through there, the mold growing on your house from thing. And, I know they're not distilling it, but they're storing it. But I would like, they don't seem to be able to tell me what this is going to smell like. Well, if they don't know what it smells like, who is?
About 25 because there's not a lot of property back there. We've been back there for a very long time, and I just hate to think that we're going to be forced off of our properties because of a smell that we've been there for 25 years. And some of the other property owners have been there even longer than that. And I don't even understand why Oldham County insists on saying that that's industrial when there's not been anything industrial back there since probably the late 70s. We've asked a number of times, why are we listed in an industrial so that they can say stuff like this when it's all residential and farm, all of it. And that includes the north side of Span Lane, which is, some of it is actually Henry County, and it includes all of Miller Lane. So there's not industrial work back there.
We actually was going to apply to get the industrial dropped off of it. So it was just farm and residential. So we were told by the board, you don't have to worry about that because you can't put in just a strictly industrial place. It has to be a house or, run a small business.
But it would be a permitted use to put in a garbage dump because of the zoning that we're in. So
if I lived on the land, I could put in a lot more about it when you start digging into it from what just people tell you. But like I said, if they can tell us what the smell's going to be like, and if they can't tell us, so y'all are just supposed to grant this valence so they can stick this in and then we'll find out. What if they decide to, hey, this is working pretty good. We're going to build a whole roll of them down through here. That valence on to say you can just go right up and down, or is it just for this one building? Just for this one building. If they go to build another building, it has to be 250 feet. Growing. There's a huge amount of land right there. Odor could get multiplied.
Okay. Thank you, guys. Questions? Thank you. All right. Anybody else wishing to speak in opposition? Okay. You heard some opposition. If you want to come forward.
I just wanted to speak because I thought they bring up an excellent point, which was being concerned, because again, we're talking about our variants and public health risks that are in our zone that we're asking for a variance from, and they talked about what's going to happen if you have an event and we get a bunch of whiskey in the containment pond, and will that run off into the farms? And I think that's a good point to talk about. And yeah, I'll let my expert talk about that.
I know there are a lot of questions with regards to this. This is, as Christopher.
Sorry, you're Diana?
Dana.
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 Okay, all right.
No problem. This is what we do, all day, most days. So if you do have questions, don't hesitate to ask. In terms of containment, that is something that anything at all in any event that would happen inside this warehouse cannot go anywhere other than the containment pond. The entire property grading is being adjusted around it so that if the littlest amount were to leak, it will divert itself to the containment pond. This is all directed to protect companies from the EPA. I think we have done a really good job at that, and So Kentucky has their own codes in terms of how to deal with, permit, and regulate distilleries, distillery operations, and storage facilities. Nobody else in the world has that. Everybody else looks to the regulations mentioned here, which are called DISCUS, the Distillery Institute, and that's what the rest of the world looks at. The state of Kentucky, insurance, the big guys, couple other legal, these kind of things, they wrote this, and everybody else looks to that. And so they're coming to us because we really have the most information on it. So containment was one question, right?
So, when you have the whiskey or the effluent that goes into the pond, how does that, is that treated, or how does that disperse in the environment?
So it can be dealt with a couple different ways. One, it can be pumped out. So it is completely contained. There's a valve in there that will not be able to be opened until it is completely pumped out. If it's a little bit, it can be treated before it is released, which is approved by the EPA. More often than not, though, we just don't really see this happening to have to use these containment ponds. That's another thing. The chance of events like this happening are very rare. Another comment I wanted to clarify is the word mold keeps getting used, and I just want to make sure everybody knows it is not mold. Mold is a completely different thing. This is absolutely no harm to humans and or animals, whether it falls on plants, grass, soil. I mean, you could eat it. I wouldn't advise it, but it is absolutely not harmful to you at all.
Is that, I believe you called it microflora? Am I correct about that?
It's called.
It's called, all right. So what are the concerns with that? Because I don't know.
None. There are none. I mean, there are no proven concerns at all. Now, there are scientists that can tell you biologically why that is. I would have to read documents and explain that to you. But the concerns are only aesthetic. And these are, in the volume that we're talking about on this property, it would take a very, very long time before you start seeing amounts of that. You just can't. There's not a lot here. And without having wind blowing through this building and blowing those vapors out, it's going to take even longer. It's just not going to happen. The other thing is to the smell. I have a super smeller. Did not lose that during COVID, which is good and bad, but I can smell anything. And a facility of this size, I can't smell it, I'm telling you. I mean, if you walk in the door of the building, yes, absolutely you can smell it. Whether it's leaking out and you're smelling it around it, you're just not going to get that. Like when you drive through Bardstown, I mean, it's in the air, it's everywhere. You can either like it, love it, hate it. You are definitely aware. The other thing is too, and I think one of you mentioned, this isn't a distillery. We're not producing that. You're not getting the smell of the high-proof alcohol vapors coming off the still. You're not getting those off the mash, off the fermenters, that kind of thing. And so the reduction of those odors are also eliminated. Other questions? Oh, this permitting? 100 feet. So two other things in terms of setbacks and permitting. One is, a couple of you have asked about who is going to look at this. The state looks at this. So all spirits projects that have a hazardous occupancy are all reviewed by the state. So Oldham County would not get the ability to say, sure, go ahead. It has to go through the state. And they have groups of people there that look at this all day, every day. Think about the big guys they're looking at. So they are extremely qualified and educated on this area to know if all of the rules and regulations are being met and followed. So that answers that. And the other one was the setbacks. So Kentucky has set regulations on the setbacks between barrel warehouses, distilleries, and property lines. They are 100 feet if you are sprinkled, and we are providing sprinklers in this. Sprinklers are not required in Kentucky for a facility of this size. We are doing that. Everybody else in the rest of the world has to look to NFPA 80, which the setbacks there, I think the ones that we're doing overseas are in about 50-foot range, and that was what their insurance company was comfortable with.
I don't know what NFPA 80 is.
National Fire Protection Agency, 80, that's the regulation that talks about building setbacks based on hazard, height, separation, and construction style. And so that's what typically dictates this. Kentucky looks at it a lot differently because we're the Silicon Valley of whiskey. Other questions?
Yeah, let me ask you, I'm going to ask you the same thing that I asked, I believe, Christopher. Am I correct? Christian, thank you. So, what other things, are we missing, are we, this board, missing to ask? And I know that might be, sound kind of weird for me to ask you, what are we, so we've talked about smell, we've talked about fire, a little bit about fire, we've talked about microflora, spillage, traffic a little bit.
Really have covered a lot of it, if not all of it that I can think of. So we've done this recently in Alabama. They were in a community there. There's a project going in. They do not have any distilleries. They don't have any projects like this. They did not know what to do. And so they've said the exact same thing to us. What are we missing? What are we not asking? Please direct us to the code that we should be looking at, and then we'll take it from there, and then we'll come back. And that's been a lot of good communication. A lot of the communication came from neighbors. It is in a residential area as well. And a lot of the questions were dealing with the microflora. And it's just, and that distillery is much bigger than what this is, and it just was not a concern. I don't think we've been asked any other questions in our history of doing this. I think we've covered it: fire, spill, sprinklers, setbacks.
Regarding the fire one, I know that propane place is right down the street, and
More concerned for that one.
yeah,
Anything else?
Discussing things like the microflora and the spillage and things like that, are those under the umbrella of the best available control technologies? Is that does that encompass all of that, or is it just emissions?
That would be just regarding emissions, is the BACT system. Yeah. Which would be its separate thing, containment, fire, separate thing. All of those are handled individually. Yes. Yes.
thank you. All right, if I can, go ahead. No, you go ahead.
I'm glad I have very smart people on my team. Just to bring you back to the legal issue again, we're just talking about the variance. We're talking about all this, but if I could just put that slide back up for you real quick, just kind of show you those whoop, that's not the one. Where are we at? Here we go. The setbacks that we're requesting, and actually that's not 500 feet, it's 250 feet. So we're talking about the areas that would be affected within that immediate vicinity, which I think you've seen are not huge. It's why I brought her back up to talk about the containment in the event of an alcohol event, because at the valid point, is that going to go on to a farmland? And no, it's not. It's going to be contained. It's going to be dealt with pursuant to the EPA regulations. And again, this is a permitted use, and all we're asking for are these variances to adaptively reuse this structure that already exists. That's what we'd ask that you do.
Thank you. If you all want to come forward.
So curious is, why did we have the 250-foot variance to start with? Why did we chose that? And now we're saying, oh, well, that's all right. We can ignore it. Does anybody have a reason why that was the set distance to start with?
Well, that would be more of a question for this side.
Or, I mean, we just come up with this from nowhere?
Well, hearing what I was explaining earlier. Well, and when we established the regulations and we did research and looked at things like, I'll call it fall zone in both calm and wind conditions and whatnot, and tried to do our best in establishing it. I do need to correct something that's been said, including we missed it. In the regulations, it says when a barrel warehouse is adjacent to residential use, not zoning, the setback is 500 feet, not 250. So even though the property that they live on and all the adjoining properties are actually zoned industrial, it's a 500-foot setback.
Okay, thank you.
And from Kentucky and living in the South End. Believe me, I'm a bourbon fan. It's just, it's like, instead of saying barrel storage, if they'd have put this out, we're gonna store barrels of whiskey here, such and such a distillery. Because I didn't even know what was going in these barrels till we got here today. That made a huge difference. You know, I've worked construction and I've seen fires from barrel houses down at Bardstown and stuff. They're not pretty. And I agree, this is a small one. It would never be nothing like that. But still catch on fire with sprinklers. It's volatile when it starts burning. I've went down and worked on it after it's happened.
Let me get you to speak directly into the mic.
Like I said, I went down and worked on them, and it's not pretty. It literally, they don't explode, but they melt. It burns hot. And I don't think that'll be a problem here, because it's a small one, and they're talking about putting everything in. But I'm just worried that this is going to grow.
Mm-hmm.
But y'all talk, this is just for this building.
It is. They'd have to come back for others.
The variances would stay in place that he has right now if
Only
they go to build new ones.
Well, they would have to come back before us. Yeah.
We'll come back and say what's going on. But like I said, if we'd had more information, y'all I'd have been better prepared if I'd known it was bourbon stored here. I think everybody would with their cups and ask for samples and, you know, well, if you want it, you know, what kind is it? But as far as the wind, I live up in the corner, 1914. Sometimes I get sawdust blowed onto my land, so the wind doesn't. That's why I built my barn that way, so I'd always have it does come over more on the railroad track. It basically follows that track instead of going up the other way. Thank you for your time.
Final statements.
I was just going to do a cleanup here. So it would appear that we need a 487-foot 3-inch rear yard variance, not a 237-foot 3-inch variance. And that would be what we're requesting. Again, that's still, for our calculations, that's still farther away than the nearest residence.
Put the slide back up that has the actual fallout.
Which one? The one with the prevailing winds?
Yeah, no, that one.
That was 1,000 foot. So if you cut that in half, I think you can see half would be right about there, which is still away from that residential unit there. And I believe, correct, your all's house is the one up here?
Well, that's okay. I mean, thank you, but I'm also concerned with those residents that aren't here.
Oh, no, yeah, no, I was just trying to put everybody on the map here, so we're all in the same positions. So yeah, so even the 500 foot, which wouldn't be a full 500 foot variance, it'd be 487 foot 3 inches. Would keep you off of that. So again, we're looking at, are we affecting the public health, safety, and welfare in those areas that we're requesting a variance? And I believe you'll see that we put forth sufficient evidence. We would request that you grant those variances.
Thank you. Board members, questions for anybody? Before I close the floor, and it's just things to think of, if maybe Jim, you already said this, I don't know, but we do have, as a board, we do have options for the motion here. We can approve, we can deny, we can table it, we can do site visits, we can recuse, well, I guess we can't recuse ourselves, we've already heard the case, but so there are a variety of things that could happen. If you still don't feel like you've heard enough, or you have other questions, I mean, we actually have subpoena power. I don't know that we've ever used that, but so a variety of things. And please bear in mind specifically, we're just looking just at the setback variances. Before I close the floor, any questions for anybody? Okay, I'm gonna close the floor, open it up for discussion.
Well, there's a lot to digest.
I'll just say that now that I have more information, I feel a lot better about voting on this issue than I did before.
I mean, I guess I think I am. I think I started out same thing with Charlie. I was, man, I'm not prepared to do this. I don't know anything about barrel storage, and how can these guys ask me to weigh in on this? But if we keep focused about exactly what we're trying to do, I'm comfortable proceeding with this, and I'm comfortable with approving it.
So in reading section 250-320, that is specific to barrel warehouses if located in I-1 or I-2, they're bullet points, and they're not either or bullet points, they're as well as bullet points. And of course, we make judgment calls on setbacks all the time, but a 250-foot setback regulation, that's a big setback, especially when you're considering its front, side, and rear. I have to believe there's a reason for that. I have to believe that, per some of the things that Jim said, that in the state of Kentucky, some are even more than that in similarly zoned areas, some are less. Also hearing that residential usage, not zoned residential, is 500 feet, is impactful. Because of those reasons, I think you've done a great job telling us how you would mitigate fire, emissions, microflora, all of those things. Those things are regulated by different entities and aren't something that necessarily we would ever be looking at, but what we're looking at is what we have right in front of us, the requirements for the setbacks that, like I said, I have to believe are in place for a reason, in addition to all those other mitigating precautions. The gentleman also asked a question that I've been wanting to ask, that if that was put into place 250 feet, are we just able to ignore that? I don't feel comfortable just being able to ignore that, or say that it doesn't matter or that it wasn't put in place for a purpose. I'm a big advocate of new industry, and I want everybody to be successful. I'm just personally not comfortable with the extent of the variances. They are extreme. They are extreme variances of the setback, excuse me. We're talking about, if we're counting the 250 feet, a 237-foot variance. That's excessive, in my opinion. That negates any real purpose for having variances in these types of industries. If we're going to just say, well, that doesn't really matter in this case. That's where I stand on the issue.
Okay. Willing to hear a motion.
Motion to deny the application requesting a front, side, and rear yard setback variance for a proposed use barrel storage in an existing structure located at 2600 East Highway 146 LaGrange. I believe it will allow an unreasonable circumvention of the requirements of the zoning regulations because the variances requested for the side, front, and rear setbacks are too excessive and will adversely affect potentially the health, safety, and welfare of the public, per the purpose of the restrictions already in place specifically for barrel storage facilities to ensure the avoidance of hazard or nuisance to the public. And that is my motion.
Thank you. Do I have a second?
A second.
Any discussion? All in favor signify by saying aye.
Aye.
Those opposed? Aye. And the application's been denied. Yes.
A quorum, because 3 board members represents a quorum, but in the Roberts Rules of voting, you have to have a simple majority, I believe, if I'm saying that correctly. And because there was a dissenting vote to the motion, you don't have that majority. I think you have to have everyone voting the same when 2 members are absent. Is that correct? Yep.
So then what happens?
Well, problem is you'd have to go through this again.
Yeah, you've got to pull forward. You've got to speak into the mic. I'm not going to keep repeating it. He's yelling back there because we can't hear you on tape. I don't know what the rules are. You want to take a recess and maybe do a quick research and figure out what?
We're missing how many members? 2.
We have one more case to go. What we can do is
The other case,
you can excuse yourself from the last case.
Have to do, and then why don't you also take at least a 5-minute recess, because I know I need one.
Okay. All right, let's take a 5-minute recess. If I can get a motion for that.
Motion to recess.
Need a second?
Second.
Discussion? All in favor signify by saying aye.
Aye.
Those opposed? Mike's off. I need a motion to come back into session.
Motion that we come back into session.
Need a second? Discussion? All in favor signify by saying aye. Aye. Those opposed? Back in session. And Gretchen, could you read the last case for us today?
Docket OC 22-042, an application has been filed requesting a conditional use permit for a detached accessory dwelling unit and a location variance for a property located at 6635 Clore Lane, Crestwood.
Thank you. Ryan Fisher, Senior Planner, Oldham County Planning and Development. So as she stated, a conditional use permit for a detached accessory dwelling unit for a property with a location variance for a property located at 6635 Clore Lane in Crestwood. An R2 residential zoning district, sits on 6.42 acres of land. No previous site history and the case history. The adjoining property owner notices were mailed out on October 31st. Public notice appeared in the Oldham Era on November 10th. Here is the property in question and a zoomed in version for you. It's your zoning map and current structures. The proposed accessory dwelling unit will be going in this kind of general area here. To put this on here, a contours map. You'll see in the presentation later with pictures, and also I think the applicant will probably touch on this, but the way the lay of the land is that the accessory dwelling unit, along with, for the most part, the house, is not very noticeable from the road. From the road, you could actually, when I took pictures, only see like the top of the roof. So I know they're going to touch on that as far as their justification. So I wanted you to be able to see the contours of, you're looking 766 here down to about where they are being 738, 740, so 20 some odd foot drop going down the hill. And like I said, you'll see that later on the pictures, but wanted to throw that in there so you all can get an idea of the topography of the land. So the applicant is requesting a conditional use permit for a detached accessory dwelling unit and a location variance on this 6.42 acre tract. Applicant is proposing to build a 1,765 square foot, 1 bedroom, 1.5 bathroom accessory dwelling unit with a 3 vehicle garage. Section 250-040E, number 1, states that detached accessory dwelling units may only be allowed after the approval of a conditional use permit. 250-040E, number 8, states that detached accessory dwelling units shall not be located in front of the primary structure. Therefore, the applicant is requesting a location variance to place that accessory dwelling unit in front of the primary structure. And then, as I stated a second ago, according to the applicant's justification statement, the location of the ADU is dictated by the slope of the front of the property, as well as, if you saw in the pictures, the pond in the rear of the property prevents the applicant from putting the ADU in the rear. But I'm sure you'll hear more about that from them. Section 250-040E, number 5, states that detached accessory dwelling unit shall not exceed 25% of the primary structure square footage. So initially, there was a maximum square footage variance on the table. But once we got looking at it, the applicant's basement is actually finished in their primary home. So the primary home is 4,383 square feet with a finished 2,869 square foot basement, which would allow a maximum of 1,813 square feet of ADU area. And their proposal is for a 1,765 square foot accessory dwelling unit. So therefore, they comply with that regulation. So that's why we've only got 2 things to look at here, the conditional use permit and the location variance. So the ADU and the primary residence will share utilities, which complies with section 250-040, general provisions B, number 6. And the applicant meets the remaining regulations listed in section 250-040. Once again, here is the general location of the proposed accessory dwelling unit highlighted in red there on your map. Once again, the pond here in the back is one of the things they'll talk about with being unable to put it in the rear of the structure. And just here are some elevation drawings of the proposed accessory dwelling unit. Your floor plan. and the foundation plan. So here is the lay of land. This was me taking a photo from the street, so you can see the primary house from the road. You can really only see the top of the roof back here where my cursor is. And that was from standing in the middle of the street. Not very safe, but. And there's another view. This is from just to the right side of the driveway. Once again, you can really only see the top of the roof, so it gives you an idea of the topography of the land. Here's another picture from the left side, so you can see a little bit more. And just here are a couple pictures looking down Clore Lane, either direction. And then this is from in front of the house, looking out to the roadway. So once again, gives you an idea of the topography of the land in question. And then this is going to be the general area over in here. They'll be able to touch on this more of the actual location. It wasn't staked off or anything like. There was a lot of stakes actually around there. I don't know what they were all for, but may have been property lines. So they'll be able to tell you a little bit more exactly where in this general area the accessory dwelling unit will go. And then here's a picture just to the rear of the property, once again showing the pond, showing the lay of that land back there. So conditional use permit, applicants requesting that conditional use permit to allow for the construction of their detached accessory dwelling unit. And then there's also the variance on the table for the location being in front of the primary structure. So in summary, the applicant is requesting a conditional use permit for a detached accessory dwelling unit and a location variance for the property located at 6635 Clore Lane. And potential conditions of approval for both the conditional use permit and the variance. Conditional use permit and variance shall only apply to the plans considered today at the November 17, 2022 Oldham County Board of Adjustments public hearing. With that, if you have any questions, we'll entertain any of those. Or Mr. Urban has something.
I checked my email, and I'm sorry I didn't print this out, but it came at 8:30 last night, and I just got around to checking email. If you can see this, from an adjoining property owner, James and Nancy Jennings. Says, my wife and I live next door, our next door neighbors to this property at 6635 Clore Lane, and we do not have any concerns with the application and support the approval of the request. And I will print this and put it in the record.
Jim, I'm sorry, hang on. Do we know which neighbor they are? Don't say. All right, that's all right. Okay. Board members, questions for Ryan or Jim? Okay. And we can have the applicant come forward.
Yeah, and you know, I don't know why I have trouble pushing the button. Where's push the button? There.
Twice in one day. Again, I appreciate you all sticking around this long. The past 5 hours is a long day for anyone, and you guys are certainly showing your mettle here. I'll try to make this brief because largely what I have here is what Ryan presented to you. So this here is the site. And we get really just the two requests, one for the conditional use permit to build the accessory structure and one for the variance to build it in front of the residence. And the layout of this approximately 6-acre lot really requires that you do that because you'll see this big pond that's right behind the house effectively prohibits building any accessory structure behind the house. It is an R2 zone surrounded by residential zones, R1 to the south, R2 to the north, some conservation zoning a little bit farther north and northeast. Again, this was the views. You can kind of see the house because it's well down the hill. Again, the house the principal structure well down the hill. The accessory dwelling unit, we anticipate will go somewhere around these trees, a little bit, probably behind the trees, right? Yeah. Behind those trees. Again, this is the site. You can kind of see the house down here. And then across the street, it's the neighboring house. So the request here is for two things. One, the conditional use permit to build the detached accessory dwelling unit. And one for the location variance. We do not need the maximum square footage variance at this point. This was our proposed accessory dwelling unit. You can see it's kind of on really it's in the center of the property. It's a little bit to the west of the principal structure. Oh, that's kind of hard to see. That's the principal structure there that was zoomed in, and that's the proposed accessory structure. In between here, you would have your driveways. Zoomed in again. It doesn't show up so well on there. Hopefully you can see that on your screens. Again, talking about the elevation, it looks like from our contour lines, we're at about 764 feet up at the road. And then right about here, where there's currently some dog kennels, which I believe are going to be displaced, about 738 feet elevation. So roughly 30-foot drop across the property, which is important because it shows that you're not going to see too much of this if you see any of this accessory dwelling unit here. There's also this embankment of trees that runs across the center of the property that further hides the accessory dwelling unit. This is the blueprint for the first floor. You got your 3-car garage. You got a small bedroom here, a half bath over here, a full bath off of the bedroom, and then a small living area with a kitchen. The front elevation, so it's designed to maintain the architectural design style, appearance, and character of the primary structure. The rear elevation, the right side there, you can see the 3-car garage, 3-bay garage there, and on the left you'll see this is where you've got the bedroom and the living space and the kitchen. We already have a provisionally suitable site evaluation for the on-site sewage disposal system using a septic tank. And so the request is for granting the conditional use permit for the detached accessory dwelling unit and a location variance. You can ignore the maximum square footage variance since we now fit within those parameters. Any questions?
I've got just a couple. I believe Ryan had a picture that we might want to put back up, but I just want to hear it said. Why can this not go behind the primary structure?
Well, I can probably put that one back up there for you. It's because of this pond. See the pond back here?
I'm looking. Just it seems like it would fit or about where, and it looks like about a 4 or 5 foot drop, but about where the drive is, close to where the turnaround is, seems like it would fit there and still comply with regulation. Yes, you do have a 4 or 5 foot drop.
About
right there.
over in
Yeah.
here?
Yeah.
Right on that corner. I believe Hunter here can talk to that.
The biggest problem with that is there's a main drainage that kind of right on the property line and goes kind of down through there. You can't really see it, but there's a drain, and it drains in the pond, and then what created the pond is another creek, and then there's also an overflow for the pond right in that area, so it wouldn't be suitable.
And the character, just to speak of the general character of the proposed accessory dwelling unit, is it going to be similar to the primary structure?
Yes.
On the one exhibit, it's referred to as a proposed pole barn. This is not a pole barn, right?
That's incorrect. I think that might have been an early draft. But
From what I see of the blueprints, it looks like conventional building. And on this, it says proposed pole barn.
Yeah,
Okay,
no,
just to clarify that.
Yeah, the final plan is a 3-car garage with a 1-bedroom, 1.5 bath, and a small living space.
Okay.
Oh, I'm sorry. We did not swear him in, did we?
I can get you sworn in.
Yes, sir.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Name and address.
Lance Hunter Kaufman, and it's 6635 Clore Lane, Crestwood, Kentucky, 40014.
All right, any other questions? All right, thank you. Anybody here to speak in favor of the application? Opposed? Board members, questions for anybody? Okay, I'll close the floor, open it up for discussion. If no discussion, I'm ready for a motion.
2 motions, correct?
Yes.
Motion to approve the conditional use permit for a detached accessory dwelling at 6635 Clore Lane. The character and objectives of the proposed use and the potential impact on the community and the surroundings are appropriate. The proposed use will not impair the integrity and character of the zone if there are specific restrictions, location, size, extent, and character of performance. There are adequate public facilities such as transportation, sanitation, sewage, water, drainage, and access to emergency vehicles, education, and recreation. The potential conditions for approval: the conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing.
Okay, do I have a second?
Second.
Discussion? All in favor signify by saying aye. Aye. Those opposed? Okay, and the next one?
Location variance. Move to approve the variance because it will not adversely affect the public health, safety, or welfare, and will not alter the essential character of the general facility, will not cause a hazard or nuisance to the public, and will not allow an unreasonable circumvention of the requirements of the zoning regulations. Because per the justification statement, construction behind the primary structure is limited due to topography, drainage, and the existence of a pond in the rear of the property. Potential conditions for approval: the conditional use permit shall only apply to the plan considered at the November 17th, 2022 Oldham County Board of Adjustments public hearing.
And can I get a second?
Second.
Discussion? All in favor signify by saying aye.
Aye.
Aye. Those opposed? It's been approved. Okay. Tate, you're up.
I'm of the opinion that the motion that was voted on in the last is approved. There are 3 voting members of a quorum being present. The majority vote 2 votes against 4.
The motion carries, so it's been denied.
Doesn't require 2/3 of the majority of those votes cast.
Okay. Application's been denied. Okay, board members. We've got a, yeah, thanks.
Minutes.
We have to do minutes. Did everybody read them? Do we have any adjustments? Can I get a motion to approve the minutes?
I'll make a motion that we accept these minutes with any necessary corrections.
I got a second? Discussion? All in favor signify by saying aye. Aye. Those opposed? Minutes approved. Any other business? That's enough. Ryan, I do have one thing. If you could, please check on training status. Next month, December, I just need to make sure, but especially myself.
Do something online. Oh, sorry.
Any other discussion, business? I need a motion to adjourn. Oh, wait a minute. I need a motion to adjourn.
Motion to adjourn?
A second.
Second.
Thank you, Charlie. Discussion. All in favor signify by saying aye.
Aye.
Those opposed, meeting adjourned.